произнесу приветственно, все. На этом я заканчиваю.
И вы отключитесь?
Ну, конечно, особенно. Я только на это подписывался, больше ни на что. Но...
Ну, так что давайте, я понял, значит, долго.
Нет, надеюсь, что недолго. Надеюсь, ну, 5 страниц. 5 страниц у меня.
Dear colleagues and friends, we are very glad and honored to welcome you for roundtable of International Association of Constitutional Law, which is on constitutional identity, universality of constitutionalism versus national constitutional traditions. And I give the floor to the president of IACL, Professor Adrian Stone. Adrian, please take the floor.
Thank you very much. Professor Belov, Justice Maverin, and distinguished guests and colleagues, it's my pleasure and honour to speak at the opening of this roundtable of the IACL, organised in collaboration with St. Petersburg University. This roundtable has indeed been a long time coming. We were scheduled to meet in the beautiful city of St. Petersburg exactly 1 year ago, but of course we were unable to. At that time, we thought delaying for a whole year made it certain that we would be able to gather in 2021. And it's almost impossible to recall the optimism of that time. The last year has been a sobering lesson in so many ways. Of course, the worst aspect of it has been the threat to the health and welfare of so much of humanity. And on behalf of the IACL, I send to all our members and to all participants my best wishes for your health, safety, and your speedy vaccination. And I add my voice to those calling for the just distributions of vaccines worldwide. Despite these troubles, it is an opportune time for consideration of constitutional identity, the theme of this roundtable. The COVID crisis has tested the capacity of governments and therefore of constitutions immensely. There have been challenges to everyday functioning of our most fundamental institutions, with the sitting of legislatures and even elections disrupted. There have been challenges to multi-level government as federalised and devolved states have faced the complex demands as well as the positive aspects of divided government. And there have been challenges to basic rights as infection control and prevention has imposed unheard of limits on our daily lives. In light of these challenges, I welcome greatly our discussion over the coming days. They will go to the most fundamental aspects of constitutions as we investigate a number of related questions. What makes a set of governing arrangements a constitution? What makes a particular constitution that constitution? How does a constitution relate to the traditions, political cultures, and social values of a particular place? Or to put it another way, to what extent is constitutionalism a shared project among the peoples of the world? And to what extent it is the particular project of a particular polity? The answer to that last question, of course, is that constitutionalism is, and it must be both. Context is, of course, important. And we do no service to constitutionalism if we offer a bland universalism that is not responsive to the people of a particular time and place and the political change that they require. Equally, we do no service to the constitutionalism or to the people it should serve if we forget the fundamental shared values that distinguish constitutionalism as a form of government. And in our age, moreover, we must guard carefully against the appropriation of the respectable clothes of constitutionalism or the invocation of the idea of constitutional identity as a cover for arbitrary and repressive government. But within these broad parameters lie many fascinating questions and a rich set of ideas with which to answer them. The topic is peculiarly appropriate for an IACL roundtable. Constitutional identity is quintessentially a comparative question. It requires a broad understanding of constitutionalism globally. And for more than 40 years, the IACL has been engaging with constitutionalists and constitutional scholars the world over. It is a truly global organization with many member associations as well as individual members. And that gives us strong links to local constitutional scholars and practitioners. This roundtable is a wonderful example of the strength of that experience and global connection in collaboration with a distinguished university like St. Petersburg University can advance the study of constitutionalism globally. These roundtables happen twice a year in conjunction with meetings of the Executive Committee. And of those of you who are already active in the association, you will know these roundtables are but one of the association's many activities. We run other roundtables and conferences at other times. We have a junior scholars forum shortly to be held in Singapore. We have many research groups on a wide array of constitutional topics and a very active blog. To participants in this roundtable who are already active in the association, I extend you a warm welcome. I encourage you to visit our website and blog to find out about these events. And if you are not already a member of the association or of your national association, I warmly encourage you to apply for membership. I must close with some words of thanks. The organisers of this roundtable, and especially Professor Sergei Belov, have persisted in the face of so many challenges. Congratulations for pulling off this ambitious program at a difficult time. The association is grateful, and I look forward to the rest of the proceedings. Thank you.
Thank you very much, Adrian. Thank you for your support and for your strong support of our roundtable and for the support of the idea and our suggestion to organize this roundtable in St. Petersburg. Today we will talk about some specific of constitutional identity in Russia, and we will talk not only about the researchers, but also about practice of our constitutional court. And today with us, a representative of the Constitutional Court of the Russian Federation, Valery Zorkin, who was not, unfortunately, was not able to attend our opening ceremony, but Justice Mavrin, Sergei, Professor Mavrin, is today with us. So I give the floor to Professor Mavrin. Sergei Petrovich, пожалуйста.
Sergei Petrovich, the floor is yours. Esteemed colleagues, dear friends, on behalf of the chairman of the Constitutional Court of the Russian Federation, I'm happy to welcome the participants of the big roundtable discussion dedicated to the problems of the constitutional identity and values of the present-day constitutionalism. The declared topic is widely discussed, and sometimes it leads to heated discussions. Quite recently, it turned into this topic of discussion, but constitutional identity is not a new phenomenon. It's rather a feature typical of any national state. It can be defined as a well expressed in the fundamentals of constitutional the national states as social cultural contact, depending on the historical development of the country. It's a complex, faceted phenomenon which is closely associated with constitutionalism, and that's why it has legal grounds. But with all of that, it goes beyond the limits of the legal sphere, permeating many aspects of public life. This issue as a phenomenon, as well as the issue of the protection of the constitutional identity of the Russian Federation, many times turned into the topic of discussion of specialists and professionals. And the chairman of the Constitutional Court of the Russian Federation, Valery Zorkin, paid a lot of attention to it in his work. The term of constitutional identity in the Russian practice for the first time emerged in the decisions of the Constitutional Court of the Russian Federation. For the first time, it was used in 2015, when there was a claim from a group of the deputies of the State Duma who contested the constitutionality of the ratification by Russia of the Convention on Human Rights and Basic Freedoms. Then in 2016, the Constitutional Court assessed the possibility of the enforcement of the decisions of the European Court of Human Rights, which doubted the compliance of the convention to the norms of the Russian constitution, limiting the active voting right of the individuals contained in custody. And the approaches to this particular problem are retained in the practice of the Constitutional Court now. The very term of the constitutional identity in the Russian constitutional and judicial practice is closely related to the understanding of the need to protect the Russian Federation from the spread of the extreme forms of supranational regulation. And with all of that, the intervention of the supranational legal standards into the national legal system is not exclusively Russian. We can say today that this problem has emerged, and many of the national authorities of constitutional justice began to understand what it is about in other countries apart from Russia. And this emphasizes the need to discuss it today at the roundtable discussion. Any national state, when forming its legal system, reflected in it specifics of the attitude to the situation in the world, the attitude to justice, relationship between people, to the humanity, to society and individuals. And history reflects these ideas that are very often universal: a life to live in peace and harmony in the atmosphere of respect. These were intuitively perceived values, and they're in the basis of the concept of the natural rights, human rights. And one of the greatest achievements of humanity was the recognition of these rights as integral and universal. And these rights are reflected nowadays in quite a number of interstate agreements signed by the states, which have reached mutual understanding concerning the content of different types of rights. The supervisory bodies of these agreements, interstate judicial bodies, for example, turned into a very important element of the protection of human rights. So the practice expanded the notion of the rights of human beings, of man and citizen. And when we use the abstract norms, it's very important to understand the specifics of this particular country. This is important for the functioning of any court. Without the proper interpretation, otherwise this might turn into an entity being too far away from the real world, from the technical progress, from the public relations, and from the expectations of real people. With all of that, the International Court, as it appears, sometimes can give had meaning to the standards which are accepted by not all the states at all. The states which had not been involved in the drafting of those, and the attempt of enforcing notions to the society might and should be limited to a certain extent. And the European Court for Human Rights indicates that the national authorities are in the continuous contact with what they call the living forces of the society. And thus, they're able, better than any international court, assess the local conditions and needs. I assume that this is quite an unusual combination of words, but it correlates with the constitutional identity. Unfortunately, in a number of cases, the actions and the solutions and decisions made on the basis of these living forces, according to the European Court, can contradict the conventional norms in their interpretation of the by the court. And these cases are not numerous, but they are significant examples of that confrontation of the constitutional identity and universal law order, as understood by the International Court. Talking about the situation of potential conflict of the national constitutional identity and supranational law order, it is necessary to mention the changes, the amendments of the Russian constitution, which consolidated the possibility to recognize the impossibility to enforce on the territory of Russia certain rulings of the International Court or Tribunal. In this context, I would like to mention some ideas that have already been voiced several times. The constitutional regulation and Constitutional Court of Russia consider these mechanisms as mechanisms, first of all, intended for the development of a compromise and, if possible, of the mutually acceptable variant of the enforcement by the Russian Federation with the compliance to the constitution of the Russian Federation. We should remember that the need of the consolidation of this particular form of interaction with the state entity emerged along with the cases, along the collusions, which resulted from the fact that the norms of the law or the norms and the understandings of the society were doubted and contested by the European Court for Human Rights. With all of that, the researchers of the global processes indicate that the global crisis more and more often turns the human society towards the trend of the rebuilding of the national identities rather than to globalization. Thus, the pandemic, the beginning of last year, this year, brought about a new set of contradictions between the universal values and national regulation. And this definitely had a different impact on different states. The development and introduction of vaccines were not free from the promotion of the interests of individual states and from politicization, unfortunately. Along with that, the intergovernment contradictions became even sharper, and the egoistic trends within the states, the population of which did not always treat it properly, the rendering of international assistance. So these problems, which seem to be quite far away from constitutional identity, demonstrate how easy it is to turn the notion of one's uniqueness into the transformation of the relationship between theirs and ours. And this works against democratic values, and sometimes this leads to protection of the rights of the minorities. And with all of that, the exception of universal values is also associated with the values of constitutionalism. In real life, this is a difficult task for many. Very often, we cannot expect success that soon to come. But this confrontation should not be inevitable. These principles, the legal principles, should not create any danger to the constitutional identity of the spaces of different states. And there is enough space for the application of these values and principles. The combination, reasonable combination of unique and universal should enrich rather than lead to disagreement. The key answer to the emerging complex problems is a dialogue between the equal partners permeated with mutual respect and the high courts of the Russian Federation are involved in this dialogue in the format of bilateral and multilateral conferences and meetings, and in an indirect way, which is even more important, addressing the practice of the inter-government judicial bodies in the decisions and in their preparation. And we can see the willingness of our partners to cooperate. The European Court for Human Rights on the whole is orientated at the considering of the decisions of the Russian court when making up with their decisions, and of importance also when we discuss the constitutional identity and globalization is to consider the attitude of this academic community. That's why of great importance is the participation of researchers and practitioners from different countries. I'm sure that the discussions which will take place today and in the next days will contribute into the understanding of the constitutional identity and its correlation with the universal values of constitutionalism. I wish you successful work and interesting discussions. Thank you for your attention. Thank you, Sergei Petrovich.
Thank you so much, Professor Mavrin. I will say just a few words on behalf of the local organizers of this roundtable. And first of all, of course, I should again express my sorry that we are not able to welcome you in St. Petersburg, and you are not able to visit our city and our university. I hope that we can do this on some other roundtable in the coming years, and we will have a chance to organize one more event. But this roundtable, of course, aimed to make a bridge between the scholars, the constitutional law scholars in Russia and abroad, which is sometimes is not good enough. I mean that the International Association of Constitutional Law, when it was founded in 1982, in the just several decades ago, aimed to make this place for dialogue between the scholars from different systems, and it was the time of the Cold War. Today, fortunately, we live in much different circumstances, but still sometimes it is not enough mutual understanding of basic principles and basic ideas of constitutionalism, both from practical and theoretical point of view. And of course, also some role plays the not enough involvement of Russian scholars in international events and in international research projects. And I hope that this roundtable, as well as possible roundtables, which we will be able to organize in St. Petersburg in the future, under the auspice of the International Association of Constitutional Law, will make a chance for this dialogue and for this involvement of the Russian constitutional law community into the international community of constitutional law scholars. So I want to express my deep gratitude to Adrian Stone and to the Celine and Jose, the presidents of the Committee of International Association, for Roundtables Commission, and for their support and their efforts on our roundtable organization, as well as my colleagues who helped me with this organization. Anna Gritsenko is just sitting next to me, but I hope that many other colleagues who were involved are also need to be mentioned. So I also want to say a few words about our partners who supported our roundtable, and you can find information about them on our website. So without their participation and without their help, it could be quite tough to organize our event. I almost forgot to draw your attention that in chat of our opening ceremony session, you can find a link to chapter of a recent book by Valery Zorkin, the Chief Justice of our Constitutional Court. And this chapter is about the constitutional identity concept, and it is in English, and I hope the participant will find interesting reading of this chapter. So we can also circulate the chapter as Justice Zorkin asked us. So if you have technical problems with access to this chapter with this link, please let us know and we will provide you with this. The last point I wanted to mention on the opening ceremony is that we did not announce before that we would be happy to see materials of this roundtable to be published. So if speakers or participants of our roundtable would be ready to send us articles on the topic of this roundtable in all the dimensions of different sessions of our roundtable, we would be happy to think about publishing edited volume or special issues of a journal, depending on how many colleagues will be ready to be involved in the project of publishing materials of the roundtable. This is a kind of following up the event, and I do hope that you will support the idea of publishing these materials. So very last point I need to mention is that in the program, the sessions are numbered according to the general idea of some development of the idea of the concept of constitutional identity. But due to some organizational reasons, due to differences in time zones, we needed to mix all the sessions, and right after, in some minutes after our opening ceremony, the first session will start, but this will be session number 5. This will be a session about the constitutional identity in the Russian Federation and in the Russian scholarship and in the Russian practice, in the practice of Russian Constitutional Court. And the most theoretical and the most global general session on the theory of constitutional identity will run today later after the session number 5. So please take this into your consideration, and I hope that this will demonstrate on one hand the logic of our program, and at the same time will let you to follow the discussions on different topics within the general topic of our roundtable. So I hope that everyone will find interesting presentations and will be involved in the discussions on our sessions. And I welcome you to St. Petersburg, though virtually. Thank you. Dear colleagues, I wanted to remind you that our next session, which will be on constitutional identity in the context of recent constitutional developments in Russia, will start in 1 hour. So it will be 10:30 on UTC time, which is nearly in 1 hour. Hope to see all of you on this session. Thank you.
Well, ladies and gentlemen, I think we can very soon start with this session. My first question, can you understand me? Yes, very good. Thank you. That's the first. Then I am absolutely not sure whether we should wait for Sergey to say something or our administrator. I'm not really sure how this will work. Sergey, are you there? People are still coming in, which is good. So we'll give it a couple of more minutes. Hi, Sergey. Very good. Yes, I was just wondering how whether you were going to say a couple of words first, or should I just start?
I'm very happy to welcome.
Thank you very much, Sergey. That was very kind, and I now see the latest version of our schedule. I must admit, since early this morning, I was busy here. So the very latest development about our distinguished colleague Ken Nakayama, who will speak, came a little bit too late. That is 3 minutes ago. So I will not be really able to say a lot about our colleague, but we will certainly hear from him. I'm very happy to be able to sponsor this, to chair this session number 5, which I think goes very much to the heart of this entire issue and is especially important for our hosts in Russia. We have 3 guests, as you probably saw. We have William Bartlett, Gadis Gadjev, and Ken Nakayama. Professor Gadjev is justice at the Constitutional Court of the Russian Federation. He graduated from the law faculty of Moscow State University in 1975. He wrote a PhD thesis in the field of agriculture and later doctoral dissertation on fundamental economic rights, a comparative study. He then held several ministerial posts, was also a member of state parliament, and since 1991, he was elected as a justice at the Constitutional Court of the Russian Federation. He has written extensively on law, a couple of 100 papers, 5 books. He is now the head of the Civil Law Department at the St. Petersburg State University Higher School of Economics. And one point I found especially fascinating is a personal passion. He is passionate about pigeon farming, and I find that very nice. Professor Bartlett is associate professor at the Melbourne School of Law. He holds a bachelor degree in international affairs and public policy from Princeton University. He speaks Russian, so this is really a topic for him. He has a JD from Stanford Law School and a Doctor of Philosophy in Soviet History and a Master of Philosophy in Russian and Eastern European Studies from Oxford. He has been prior to becoming an assistant professor, he has been assistant professor in Hong Kong, a research fellow in Columbia University in the United States, and a fellow of the Brookings Institute. His special interests are historical and comparative questions, especially with respect to the former Soviet Union and today's Russia. Unfortunately, and I am truly sorry for this, dear colleague, Professor Nakayama, I am not unable at this moment to provide any information about you, as it was only called to my attention. I think you came in on a very short notice, which we are all very, very grateful for. So please excuse if I don't say anything about you at this moment. We will hear from you, and I think we will hear from the three of you simply in the order that is shown in our schedule. First, Professor Bartlett, then Professor Gadzhiev, and then Professor Nakayama. And after that, we will have enough time for a very nice and long discussion. And I hope many of you will take the chance to participate in that. Professor Bartlett, the floor is all yours.
and structure. And I say this against the background of some writing that has been written in and some positions within within Russia in particular, where there is some question about where the basis is. And I quote from Valery Zorkin and Gadis Gadzhiev, who's on our panel today, discussing how the doctrine of constitutional identity presupposes a non-textual understanding of constitutional changes, including the use of the achievements of modern hermeneutics, which has long gone beyond the interpretation of exclusively text. So I want to today push back a little bit on that and make the claim and make the argument as strongly as I can why it's important for us to look at text, why we need a textual theory of constitutional identity, and what that means and how that might play out in a few different contexts. And in particular, the claim I'm going to make is that we need to have a textual theory, because if we don't have a textual theory of constitutional identity, we are moving away from a legal conception, a legal argument, because of course legal arguments are based primarily on text, whether it's arguments about statutes, whether it's arguments about constitutions or executive acts, they're based on texts. That we're moving beyond that, and we're moving into the realm of politics. And we want to try to maintain an autonomous or a semi-autonomous zone of constitutional and legal argumentation. And the way to do that is by relying on at least beginning the process of understanding constitutional identity, looking at text and structure, and then moving to other extra constitutional or extra textual, extra structural ideas. Now, two terms I want to introduce as I go through this. First is a distinction between two ideas. One is the idea of a constitutional principle. A constitutional principle is, and this I draw from, this distinction is not mine, this is one I draw from and I very much agree with, but it is not one that I came up with. It's advanced very, very well by Nick Barber in his book Principles of Constitutionalism, which is just published a couple years ago by OUP. The idea here is that principles are universal, right? And we can find them in many constitutions worldwide. In fact, they're in the Russian constitutions in chapters 1 and 2. These include concepts like rule of law, democracy, separation of powers, rights protection. The key thing about these types of principles, though, is that they are partial and under-implemented. That is, they do not suggest a set of best practices. They do not suggest that you must follow a certain type of way of actually implementing it. And that's the second term that I'll be using in my talk today is what are called a constitutional practice. A constitutional practice is the implementation of that constitutional principle. Now, we can think of some classic examples of how constitutional systems take these broader partial principles and implement them through practices. We can think of parliamentary systems versus presidential systems versus semi-presidential systems, and so forth. Different structures, different institutional ways of achieving these. We can think of different forms of rights review. The European and very much German concept of proportionality, which is very popular in some parts of the world. Other rights review, other forms of rights protection use standards of review, so different. But the idea here is you can have difference, but they're still, what they're doing is engaging with the universal principle. Okay, so that for me is an important way of understanding what I'm going to advance as this kind of textual theory of constitutional interpretation. A second kind of key conceptual distinction that I want to introduce is one that there are three positions that a constitutional system can assume with regards to these constitutional principles and practices. The first is a convergence position. And this is one that is deeply problematic. And this is one that from my reading of Valery Zorkin, from my understanding of the work of many Russian members of the Constitutional Court and others who are concerned very much about constitutionalism becoming a convergence project. And I, on that point, agree 100%. I agree that constitutionalism is not a convergence to a particular set of best practices. We're not all going to look like the United States, the UK, God forbid, right? We are the process of determining constitutional systems is one of interaction and engagement. And the country I sit in today, Australia, is a good example. Australia has a constitutional system, but does not have a Bill of Rights, right? That is a significant difference. So we can see diversity, right? So convergence is not the position that I think we want to be in with respect between our constitutional systems and these principles, these overarching principles. Similarly, we don't want to be in a position of resistance. Resistance is one that is a position where a particular constitutional system simply fails to engage at all with these principles. It is simply doing things that are unconstitutional or is using national history as a way of resisting. And the final is an engagement position, and this is the one that I suggest is the most effective and the one we should be following. And this is where individual countries engage with these principles by determining their own context-specific practices. Okay, so what is the position in Russia today? I think it's unclear, and as we've all said, and I think as we'll be seeing across the course of today, we're going to be seeing is a significant ambiguity and still questions. Constitutional identity is a new idea, and we're still developing some of the ideas. Now, I do see some elements of resistance discourse in some of the ways Russians and the Russian Constitutional Court has discussed this, as well as engagement. And I think it would be, I'm going to be pushing today, or the argument I'm going to make is that an engagement position is the preferable one. And in particular, I'm going to argue that constitutional identity in Russia, if we look at the actual text, if we take a textual approach to constitutional identity, that requires us to engage. It requires the Russian Constitutional Court, it requires constitutional identity as a discourse to engage, because the Constitution itself contains these principles, right? These textual principles in chapters 1 and 2. So a textual theory of constitutional identity requires engagement. Is the position I'm taking today. So why is this? As I said before, this serious engagement, and I'm going to give you two examples of what this serious engagement looks like, is grounded on the text and structure, and particularly those fundamental commitments in chapters 1 and 2. Now, I'm going to briefly do this for those who are less familiar with the Russian Constitution, and apologies to those, obviously, who are Russian constitutionalists. This is going to be quite basic, but the key points I want to make about the text and structure are as follows. The Russian Constitution has two foundational chapters, chapters 1 and 2. Chapter 1 is the fundamentals, the osnovny of the Russian constitutional system. The second is the rights and freedoms of the individual and the citizen. Chapter 1, I'm not going to read these out in too much detail, but the idea here is that Russia is a демократически федеральное правовое государство. So a democratic federal law-bound state. Man, his rights and freedoms are the supreme value. State power shall be exercised on the separation of powers. So we see we see these principles, these universal principles of constitutionalism contained and fundamentally in these basic provisions. Now, interestingly, there is, of course, like every constitution, some textual suggestions that the system itself, even though it is engaging with these principles, also has its own unique practices and so forth. And we can see at least some of these even in these foundational chapters. The Russian Constitution, like actually many other new forms of constitution like Colombia and others, combines these principles with the idea of a social state, right? The Russian Federation is a social state, and also talks about the ideas of rights and freedoms not violating others' rights and freedoms. Okay, so there's a balance between individual rights and the rights and the public interest and the collective interest. As well as in Article 55.3, quite a lot of things upon which rights can be limited in a proportionality type way, including for the defense of the country and security of the state. So a clear look at the Constitution suggests, first, a textual approach suggests that there is serious engagement, and there is that these are fundamental principles of the Russian constitutional order, and that they should form, therefore, part of Russian constitutional identity. Similarly, we see ideological diversity, but ideological diversity within limits. And the idea here is that these provisions, these textual provisions, suggest that there is a there's a commitment to particular principles, but these are to be balanced against the interests of the state because of the additional importance of the state and collective interest in Russian society. And of course, the framers and the writers of the Constitution, when they drafted the Constitution, were thinking about this, right? So we can begin to see within the text itself the idea of an importance of creating its own unique form of constitutional identity, but one that still engages rather than resists these principles of these universal principles of constitutionalism. And of course, these provisions that I've been talking about are entrenched against change. They're essentially higher values and higher provisions than the rest of the Constitution, including the parts of the Constitution that were amended last year. Our chapters 1 and 2 are protected against amendment. The only way that those can be amended is by a 3/5 majority of the lower and upper house, followed by a constitutional assembly, constitutional sobrania. So it requires these are higher. So if we look at text and structure, we see this commitment play out. So therefore, what does this suggest? Well, a textual theory of constitutional identity suggests engagement. And engagement, I argue, actually means that the court needs to be more active, right, in protecting individual rights than it has been in the past, and that it needs to be more critical. The idea and history can be brought in, but we're using that if we're thinking of text as a critical aspect, and text and structure is the starting point of constitutional identity, we need to engage in light of that text and structure. And I'm going to give 2 examples, and then I'll stop because I see my time is ticking away. 20 minutes goes by quickly. First is to talk about the Anchikov and Gladkov case, which is one of the first case where the Russian Constitutional Court actually held that a decision was impossible to implement, a decision of the European Court of Human Rights, on the basis of what we now see in the amended part of Article 79, that decisions of international courts or international bodies that are contrary to the Constitution can be rendered impossible to implement, not executable. And at the center of this case, in short, was Article 32, subsection 3, which says that this is a part of the Russian Constitution saying that citizens detained pursuant to a sentence imposed by a court shall not have the right to vote in an election. And the question that was posed in the holding that the European Court of Human Rights said was the European Court of Human Rights in the Anchikov and Gladkov case said that this blanket ban was in violation of Article 3 of Protocol 1 of the European Convention. The court gave in many cases I think in this case, quite an interesting outcome, including an actual suggestion of what the engagement position would look like. The engagement position is saying something like, well, the constitutional text itself cannot be amended. And in fact, that's not something that the Constitutional Court is interested in doing, but that there are ways in which legislation could be made. And in fact, that the Constitution could be that legislative classification of punishment for minor crimes could be changed in such a way as not to fall within the particular words of detained in a detention facility, so that legislation could be changed such as in a way to engage with this. And the point that I want to make is that I think that holding, which was one that was a suggestion rather than an order to the legislature should have been stronger. In the engagement position, the Russian Constitutional Court sort of said, we find that it is impossible to implement in the sense of changing the constitutional text itself, but we find that it is possible to implement. And in fact, we think that would be right and within our obligations to say to, as the court does on other cases, to say to the Russian Duma, to the legislature, federal legislature, you need to amend legislation to ensure a particular legislative classification so that particularly minor crimes don't get put under the framework of detained in a detention facility. And this actually would fit with Russia's principles in those higher chapters, and particularly chapter 1, Article 1, the idea that Russia is a democratic state with a Republican form of government, the importance of ensuring voting in this system. In that case so it is an engagement because of the importance of that text as well. And the final one is to talk a little bit about how constitutional identity might be used in the context of rights adjudication internally. And here I draw on some of the work of Sergei, whose discussion of what he calls reverse proportionality, how the Russian Constitutional Court's position on rights has been deferential to the state. And in fact, Sergei argues in his 2019 article that in many cases, the position the Russian Constitutional Court has taken is one very close to the rational basis test in the United States, which is a position that is very deferential and that does not particularly look particularly closely at the legitimacy of the state interest, or even more closely, also does not test whether the law is the least restrictive means to achieve a particular outcome. And the argument I want to make today is that I think that this, and some people have made arguments suggesting that this reverse proportionality approach is justified by Russian constitutional identity. And I want to say that is not, if we take a textual theory of Russian constitutional identity, we should see that actually this is too weak of an approach to rights adjudication. And in fact, a textual approach requires a much more searching position on this. And the case of the one example I want to use, and this will be the last thing I'll say before I stop, Uwe, because I know I'm reaching my time, is to say that is a 2019 Russian constitutional case involving a dual citizen, Mr. Finkelstein, who owned a media company who was challenging a law that limited essentially the ownership of dual citizens or anyone with foreign citizenship, even those who were Russian citizens, to less than 20% in media companies. The Russian Constitutional Court in this case held that the law was at least legitimate with respect to a legitimate state interest. It struck the law down on other grounds, but did hold, and in fact, they wanted the law to be written more clearly, but they did hold that this was a legitimate law with respect to a particular state interest. I think on this is a good example where the court should have been more searching. In fact, in that to essentially a textual theory of what Russian constitutional identity requires is one that it actually engages with the idea of the individuals being the supreme value. So as a result, the court could have done two things, or should have done two things, I think, more closely. One, to what extent is information security? This was what the legitimate state interest put forward by the government. Is this a legitimate state goal? In a quite famous dissent, Konstantin Aronovsky, who's on the Constitutional Court as well, Justice Aronovsky, suggested that this wasn't a legitimate state goal. There was no evidence suggesting that this was something that would potentially and that this law was potentially actually carrying out anything that was, to what extent do foreigners suggest a threat to information security? Where's the evidence for that? That was a suggestion. The court could have, I think, should have gone into more detail on that. Second, are there less restrictive ways with respect to property rights? Because of course, in this case, this was a claim that Mr. Finkelstein's property rights were being violated by this law. So again, the idea here is that, again, constitutional identity, and one that is a textual and structural theory of constitutional identity, requires a stronger approach and requires a more active court. So in conclusion, finish with this. The idea that I want to put forward today is to bring our attention to methodology, to begin to think about methodology and its importance in determining what constitutional identity is, and that we should be looking at the text and structure of the relevant national constitutional text. If we do that in the Russian context, I think what it suggests is that constitutional identity is not a shield against international or supranational, but what it suggests is an engagement, so that there can be an attempt to find a particular way in which a principle in the text itself can be carried out within the Russian context, and it actually suggests in this case that the Russian Constitutional Court, should take a more active position when the state is asserting particular public interests or public interests against the individual. In this case, because a textual theory of constitutional identity and a structural one is grounded in those fundamental values in chapters 1 and 2. So I'll stop there. Thank you.
Yes, Thank you very much for that very concise and clear presentation. I think we all learned a lot about the intricacies of this topic, and we will simply continue. With Justice Gadjev, who now has his 20 minutes. Please.
Is it possible to begin?
Yes, please, Professor
Yes,
Gadjev,
yes.
please begin. Please, thank you. Professor
So
Gadjev, we
if I will
cannot
speak
hear
Russian,
you.
I will speak Russian.
Okay.
Can you hear me now? Can you hear me? Yes, it's okay now. It's okay. Right, so if I'm not mistaken, the first mention of the term constitutional identity appeared in the decision of the Constitutional Court in 2016. And that was associated with the complaint filed by Russian citizens who were convicted for murder and who wanted to take part in the federal elections. They were denied this right because, according to the Russian constitution, individuals convicted and in custody do not have a right to vote and to be elected. Now, since there was a dispute there, and the position of the Constitutional Court and the European Court for Human Rights had different standpoints on that. The European Court stipulated that Russian citizens, even those who were in custody, had a right to vote. So then there appeared that idea, and judging by the way it was used in that particular decision, the purposes were defensive. I mean, well, this is very conventional, of course. Defensive, meaning that the idea was to mitigate the risks when Russian law system, a legal system, was standing against the idea of the proponent of the universal constitutional idea. Russia believed that the European Court, that these individuals were to be granted the right to vote. Although the Constitution did not provide them with that right. The Constitutional Court, in this sense, was in a very difficult position because the Constitutional Court needs to provide the supervision over the enforcement of the constitutional provisions. So here we come up across the following question. What should we do when a state is being pushed towards a sort of accelerated work on the promotion of the universal idea of constitutionalism, which is generally accepted in the Western world? With all of that, we can ask another question. And this canonic version, is it always being used the way it should be used? I mean the words of Jürgen Habermas in his book, which is entitled The West Split, in which he stipulates that although the liberal version of constitutionalism is neutral, objective, and of course should be universal, nonetheless, it is used in reality as a factor of geopolitics. And it's a form of West centristic dominating discourse. And this discourse will, of course, compete with other non-Western discourses. I mean the Asian declarations of human rights, in which there are at least two ideas contained. First, the idea that human rights should be formulated and should be put in practice considering the regional specific social and cultural context. And the second idea is that there should be considered the constitutional identity of each particular state. So that means that the notion of the identity, constitutional identity of the state is not very popular in the Western constitutionalism. But the Western constitutionalism is not the whole world. In other countries, this issue is quite a topical one among the specialists on constitutional law.
When a couple of years ago in the Constitutional Court, we were conducting a special conference dedicated to the constitutional identity. Angelika Nussberger, the deputy head of the chairman of the European Court on Human Rights, and she cited my article where I was stating that an integral part of the judicial doctrine of constitutional identity is the realistic assumption that there might be temporal inefficient results on achieving compromises in terms of obtaining multinational European law order. In her speech, she used a very interesting metaphor of red flags, which identifying the boundary which European Court might never cross and thus will not compromise. These red flags do not allow European Court to compromise on the issue. But in Russia, there are also certain understanding what is the red boundary, what is the red line. And this is the notion that we are discussing today. This is the notion of constitutional identity. Since we're talking about a very important sphere which emerged in the science of constitutional law, and it should be deprived of the shell of mystery. This category, these words have a certain mystery behind it. And the mystery of constitutional identity allowed in one of the neighboring countries of the Baltic region, according to constitutional identity, to prohibit Russian language being taught at schools, despite the fact that a little bit less than half of the population use the Russian language as a native language. When talking about this concept, which is used not only in Russia, as you can see, it is worth noting that this concept is rather blurred, vague or uncertain. Remembering the book that many of you might have known and might have read at school, the Mark Twain book about the prince and the beggar, when the beggar turned out and found himself in the palace, and he uses the royal stamp in order to open the nuts. Well, I wouldn't like us to find ourselves in such a situation that such notions as cultural identity was would be used as in such a wrong way as the character in the above-mentioned book. We should take into consideration the difficulties of formulating what exactly identity is, be it in a big country with federative government. When we talk about constitutional identity, we should bear in mind that in this territorially large country, which has one of the largest territories in the world, there exists multinationalism and many religions can be found and different ethnic groups. And through religion and through the ethnic groups, it is very difficult to find the common social grounds for constitutional identity. Social foundations of constitutional identity might be the general civil values, such values which are the result of historic development. Many centuries are required for them to form. And I think that this is what is understood in the first two articles of the Russian Constitution. That is, the multinational people of Russia has the uniform destiny on its soil. The objective system of constitutional values also encompasses the phrasing from the 8th and 9th lines of the Constitution. People of the country value the memory of their predecessors who gave us the belief in truth and justice, and the belief in truth, justice, conscience. These are universal general values. In the Declaration on Human Rights, in Article 1, it is stated that all people are born free and equal in their dignity and their rights, and they have reason and conscience and should act in respect to each other in the spirit of fraternity. But if we talk about one of the ideas used in this article, that is the idea of fraternity, although this idea is in a way universal, it has its separate sense in the culture of Muslim countries or in China, for example. The key Confucianist notion, Zheng, is very syncretic, is highly syncretic, and it encompasses the respect toward people, the respect of their dignity, justice and fairness. In the Russian language, there isn't such a word which could pass all these different concepts of this notion. Philosopher Kunzi wrote that Zheng takes into account Shu, that is reciprocity, which is the basis of solidarity and solidarism. And when it was mentioned by Nussberger in her article, and when creating the text of the Declaration of Human Rights, China offered to use this philosophical concept in the text of the Declaration. It was very difficult to use it, and it was included through the word conscious. But when this article is read in China or in Russia, the understanding of the word conscious is different, since the context and the philosophical tradition of Confucianism and the lack of such a concept and such a philosophical tradition in Russia do not allow the people of these countries to understand this notion similarly. I want to say that universal values exists within the context of a certain culture, and this should be remembered, both in the historic and sociocultural context. And I suppose that the justices of the Constitutional Court can well understand that not each case of the conflict of supranational, in this case of European right, and the requirements of the Russian constitutions might be considered as the impediment to the Russian constitution. Not certain norms require defense, being defended and protected. Very important parts of the constitution which form the core of the national constitutional order. And not all related to the sphere of the law traditions form this core. Thus, it is necessary to create the methodology of differentiating the legal values, the destruction of which might harm the constitutional identity, and the identification of wrong values which are based on prejudices or stereotypes of common perception. This is a very wide spectrum, and it includes both constitutional identity, which is one part of the spectrum, but at the same time, there might be the invertiveness of the community reasoning, and it might border anachronism sometimes. There might be cases when there is such a mix of both ideas. In the case of voting rights of people detained in custody, the Constitutional Court did not state that the constitutionality of Russia might be considered according to this norm, in accordance with which those detained in custody cannot vote.
The Constitutional Court limited itself to the stipulation that the engagement of the legal systems of Europe and Russia is impossible under conditions of subordination. A dialogue is the only way, is the only basis for the balance. And the European Court on Human Rights should respect the national constitutional identity. And the European Convention is very much focused on that. I would agree with the opinion of Angelika Usberger, who says that in the case when the right for voting was discussed for the convicts, the Constitutional Court did not close the door for the enforcement of the European Court decisions. The door is half open, and a similar situation occurred in Britain, the Hearst case against the UK. And we remember that the conflict between the national government and the Committee of Ministers of the European Union concerning this particular decision, its enforcement, the enforcement of the European Court decision, was successfully resolved. The formula was found. Now, colleagues, I do not go into any other details concerning the judicial concept of the constitutional identity. Am I still within the time limit? Am I?
I think.
Do I have time?
Two more minutes.
Yes, I was going to say some things that I talk about to my students. Conflicts and situations that makes us think about the constitutional identity. Well, in any case, I remember a well-known case first resolved by the German Constitutional Court, then the European Court, the Hanover Foundation case. There was a conflict based on the values, on the assessment of those. The German court was on the side of protecting the value of individual's life. The European court believed that the right of the media, of the freedom of information was prevailing. So this difference of national German culture, for which it was important to protect the dignity and to demonstrate respect to individual life, and a very different value, the freedom of expression. And in American law, as far as I remember, it is the supreme right. It's at the very height of the hierarchy of values. I remember that when the Supreme Court of the United States heard a case on the Pentagon secret archives, one of the judges there, one of the judges involved in that session, asked a question. He addressed this question to the defense attorney. The defense counsel of the paper that was going to publish the classified materials. He asked, rather, and what if we allow publication of these materials, will it not happen that after a short while we have to indict quite a lot of young people and execute them just because these young people at that particular period of time were drafted? They were drafted and were soldiers fighting in Vietnam. I remember that one of the judges at that particular time came up with his dissenting opinion, and I cannot say that I agree with that opinion. He said the following: if this sentence is enforced, and if several hundred military men have to be executed, this is not too high a price to protect the freedom of speech. So when these conflicts reach this highest possible level, these conflicts are not the conflicts between the equal values. In the American tradition, this conflict is not a conflict of the equal values. In the German constitutional culture, it's a conflict between equal values. And we should understand that there is a very high level of moral cost of that particular decision. A decision made following this particular approach, when one value is an absolute value and when it's superior over other values. So this example, I think, shows the difference between the constitutional identities, and which demonstrates that the legal cultures of different states are different. Thank you.
Thank you very much, Professor Gadjev. This is really kind, very wonderful presentation, also very clear and full of points that we will certainly be able to discuss later on. I think we will simply continue and go straight on with Professor Nakayama, who also has his 20 minutes now. Professor Nakayama, please.
Thank you, Professor Kisher.
Ladies and gentlemen, thank you for the chance to speak today. Очень плохой звук. The sound is very bad.
Professor Nakayama, sorry, the interpreter just said that the sound is very, very bad. They have problems translating. Could you maybe move the microphone closer to your mouth or anything like that? They seem to have a problem. Could the interpreters please just tell him directly what they need?
Все равно, ничего не меняется. Nothing changes.
I want to talk about the supremacy of law dedicated to the 20 years of the Constitution of the Russian Federation, which took part in Russia in 2013.
Высказать свое мнение о конституционной идентичности, которое сегодня активно обсуждается. The question is of the constitutional identity, the hot topic for today, and it's associated with the all-European idea of the supremacy of law, or maybe it is associated with the cultural objectivism. In the Western values, the system of values. The first question that is going to be discussed at this session is in the following. The constitutional identity is actually associated with the European protection of human rights. And then there is another question emerging. How justified is the...
As for the first question about the acquittal, there might be two logical answers. One of the answers is that the concept of constitutional identity cannot justify the possibility not to comply with the decision of the European Court on Human Rights. And constitutional identity cannot be used as a reason to divert from the court ruling. It can be said that the ruling of the Court on Human Rights is aimed at assimilation of the Russian legal system with the rule of law, like in Western countries. Such an approach, that is assimilation with the Western idea of natural law, is used as the opportunity to overcome the challenges of the Russian legal system and the rule of law and supervisory system. From this point of view, the notion that constitutional identity is opposed to universal values, such as the individual rights and constitutionalism, which were introduced by the Western countries. The Russian internal reaction on the decision of the European Court on Human Rights concerning the case of Anchugov, 2013, gave impetus to the concept of constitutional identity. The answer to this problem is that the concept of constitutional identity might justify diversion from the ruling of the Court on Human Rights. Unlike the above-mentioned situation, the constitutional identity might improve the guarantees of human rights of individuals in Russia. That can be seen on the example of the decision taken by the Federal Constitutional Court based on the case of Anchugov in 2016.
And so this right is also associated with executive supervision. As Judge Gadzhiev is maintaining, the Russian supremacy of law was formed thanks to the active legal activity of the Constitutional Court of the Russian Federation. The use of, in the activity of the Constitutional Court of the concept of constitutional identity demonstrates that the Russian rule of law in potential has its own potential for development. As it was said earlier, constitutional identity can justify the deviation from the decisions of the Court for Human Rights. And there is another question, though, to what extent this is possible, and what are the criteria for that particular deviation. So, as for the limits of that, then the criteria should be the following: whether the Constitution of the Russian Federation guarantees the rights of human beings better than the European Convention for Human Rights. And another question is the question of the criteria, where these criteria are followed. So in the case of Anchugov of 2016, as Judge Kazantsev maintained, being in the minority, he said that it is necessary to follow the letter of the decision of the European Court of Human Rights, even if the Constitution of the Russian Federation is more complete as compared to the respective provisions of the convention. Within the framework of the interpretation of those by the European Court protecting human rights. I spoke about the constitutional identity and whether it justifies the non-enforcement of the decisions of the European Court and what might cause this. Now, at first glance, the constitutional identity leads to the exit of Russia from the framework of the agreements on human rights. Well, in reality, that's exactly what it is. On the other hand, when the constitutional identity is established, the constitutional identity can open a way to the implementation and to the protection of values which are consolidated in the degree on the agreements on human rights. As in case of the legal system, which allowed certain convicts to vote. What are the consequences of these contradictions which might emerge when the constitutional identity is established, and where is the limit to that? At the end of my presentation, I will speak about this. Starting with the Constitution of 1993, Russia has been based on dialogue and cooperation with Europe. And the theory of networks was promoted as a method of the filling in of the correlation between the Western values and the Russian legal order. At that time, the constitutional identity was not that noticeable. But the decision of the European Court on Human Rights of 2013 on Anchugov's case led to the emergence of the concept of constitutional identity. And following this concept, in 2015, a law on the Constitutional Court was amended. As a result, the Constitutional Court of the Russian Federation became authorized to resolve the issues of the enforcement of the rulings of the European Court for Human Rights. In compliance with that authority, the Constitutional Court of the Russian Federation, the decisions of the European Court of Human Rights, which had been achieved before these two cases, were recognized to be unenforceable from the point of view of the constitutional identity of Russia. So we're talking now about the case of Anchukov and Yukos. So thus, the dialogue between Russia and Europe moved to a new stage, different from the previous dialogue and cooperation. The emergence of the concept of constitutional identity, and then the superficial manifestation of this conception, antagonistic relationship between Russia and Europe. Still, if we follow the further development of the situation on the Anchugov's case, we will discover there that, as it has been said, there was achieved a certain progress in the securing of human rights in Russia. I believe that we can see that between the European Court on Human Rights and the Constitutional Court of the Russian Federation, there is no confrontation. Rather, there is a different mechanism, a mechanism of rigid and difficult dialogue, different from the earlier one. The assumed role of the Constitutional Court of the Russian Federation changed after 2015. According to Judge Gadjiev, this can be understood as the transformation of the B into a testing ground. The development of the Russian doctrine of the rule of law as gene depends on whether in the future there will be a dialogue and there will be a special mechanism created for that, and whether we should mention here the decision of the Constitutional Court and its resolution of 14th of July, 2015. Thank you.
Dear Uwe,
Yes, well, thank you.
may I ask you to pronounce?
Sorry, Sergey, the connection is so bad I can't hear you.
Oh, sorry.
Sorry. I think there were, thank you, first of all, Professor Nakayama. That has been a very revealing and very interesting presentation on our topic. I was very delighted about all three topics. Sometimes in these international constitutional law conferences, I have a feeling that I'm not at a scholarly conference, but at a Save the World meeting, where everybody agrees with everybody on everything. And this is certainly not the case here, which I find absolutely delightful, especially because nobody has tried to moralize any issues, but this is evidently a truly scholarly debate in constitutional law. So I will now open the floor for any discussions. There have been a couple of questions in the chat, which I will soon will also try to read, but I think we will start with anybody who wishes to say anything. You may probably simply physically raise your hand or make yourself known. Yes, thank you very much. Please go ahead.
Thank you.
Yes.
Did you talk to me?
Yes, absolutely.
Yes, thank you so much. Yes, my name is Helle Krunke, and I'm a professor of constitutional law at the University of Copenhagen. And first, I would like to express my sincere thanks to the three speakers. I think they were very fascinating speeches, all of them. So my question goes to Professor Gadgiev. Thank you so much for your presentation. Very interesting.
I'm sorry, can I intervene really quickly? Professor Gadgiev, could you turn off your microphone for a second? Because I think we have this back, echo, and that makes it really difficult to understand. And you are the person that I see who has his microphone on. Please, we understood mostly what you said, but this makes it easier. Helle.
Yeah, thank you so much. So, Professor Gadgiev, thank you so much for your interesting presentation. I have a question for you, because in your presentation, you mentioned that universal principles exist within a culture. And even though we do have differences in cultures all over the world, I still believe that many of the international treaties we are discussing today build on a shared experience. They're built on a shared history for all of us, all over the world, because many of these treaties, for instance, the Universal Declaration of Human Rights, the European Convention of Human Rights, they built on our shared experience from the Second World War and all the violations of human rights during the Second World War. So my question to you, I guess it's pretty obvious, would be, do we not actually share a history, share an experience, all of us in the world, for instance, based on experiences from the Second World War? Thank you so much also for your very fascinating paper. Thank you.
Professor Gadgiev, if you would like to answer directly.
Can you hear me now? Can you hear me? Well, I try to be very brief. Well, definitely in Russia, we have universal and constitutional values, and we differ them, not simply that these are transplant norms, but this is a part of our own history. And the people views these principles of organization of social life, establish them through difficulties. And this is the experience of the country itself. I wouldn't like to talk about many things, but the principle of the division of powers is so difficult for Russia, since this principle emerged not at the end of the 20th century, in the middle of the 19th century, when there was the power of one person, of Tsar. The Tsar voluntarily decided not to control the legal system. During the first judicial reform in Russia, the first elements of the division of power emerged. And definitely, this is a part of our constitutional tradition. Unfortunately, during the Soviet era, not everything was pretty well with the autonomy of judicial branch of power. So there is a certain break in this tradition. But nevertheless, we can say that this is the unique experience of our country as well as international experience.
Thank you. I was asked to read some of the questions from the chat, so I will read the name, those by somebody whose first name I can read as Anna, and then my ability to read Russian signs goes down the drain. So here it is. Dear Professor Partlet, if I understood you correctly, then you think that Russia's constitutional identity is largely based on chapters 1 and 2 of the Russian Constitution, the so-called basics. But after all, these articles are basically a direct repetition of the norms of various international treaties and agreements. Is it possible to assume that the amendments to the 2020 Constitution most accurately characterize, or more accurately characterize, the constitutional identity of Russia? For example, believe in God, marriage only between a man and a woman, a welfare state, and of course, the memory of various historical events like World War II. Professor Partlet.
Thanks for that question, Anya. And I think someone else, I think Yulia had asked a similar question. So my view is a textual and structural approach to constitutional identity, at least starting with the text and the structure of the Constitution. So in that regard, I would say that the amendments last year in 2020, that those changes were made to chapters 3 through 8, which are don't have the same level or same hierarchy. They're lower in the hierarchy than the principles in chapters 1 and 2. And it's fair to say the principles in chapters 1 and 2 are, to some extent, they are universal principles of constitutional law. Правовое государство, rule of a law-based state. Демократическое федеративное государство, a federal democratic state. These are potentially universal ideas. But also in chapters 1 and 2, we see also some things that are not potentially universal ideas of socialne, of a social state, and so forth. So we can begin to see, I think, even in chapters 1 and 2, the reflection of a unique constitutional identity in Russia, but one that is still trying to move towards engaging with universal constitutional principles, right, through specifically different practices. Now, there might be different practices and how that carried out. For instance, we could think of the role of institutions that don't exist elsewhere in the world. The Prokuratura, for instance, the procuracy could play and maybe should play a very important role in a правовое государство system, right? We can think about the importance of that as being part of the institutional constitutional practices that bring into effect universal constitutional principles. But the idea is that the constitutional text, which I think should be the beginning point of us considering what constitutional identity is, at least if we're using constitutional identity in court, right, in a doctrinal concept, then we need to see that the highest legal norms are those in chapters 1 and 2. And they can only be changed by a federalное собрание, by an actual constitutional assembly, which has to be formed separately from the legislature through a separate process. So they are highly entrenched, they are higher law. So what happened last year to the chapters 3 through 8, and belief in God and so forth and so on, these are statements of potential values. They don't have anything to do with Russia's constitutional commitment in chapters 1 and 2 to particular principles and engaging with these principles. And my view is that the Constitutional Court should be, when it talks about constitutional identity, should be engaging with these principles and thinking about how can we bring into effect separation of powers, разделение власти. How do we bring that into effect? How do we, and of course the central problem in Russia of separation of powers and engaging with that now is how do we check the power of the office of the president, who has increasingly formal domination over many other, formally dominates the executive branch, appoints members of the upper house of the legislature, and now can remove judges on the Constitutional Court and other courts. And we can begin to say, well, is that really engaging with the separation of powers? Is that really engaging with checks and balances and these ideas and principles that are in these and that are still there? The 2020 amendments did not fundamentally change Russia's commitment and to engage with these principles. And I hope that constitutional identity should be an opportunity to see that, because that's part of the identity, is figuring out how can Russia engage and create its own practices, but ones that still engage rather than resist, right? And say, oh, well, Russia's different, therefore we can't do this.
Thank you very much. The next question comes from Martin Belov.
Thank you very much, Professor Kishel. I just want to make a short intervention comment on the methodological approach of Professor Bartlett, which I find on the one hand very sympathetic, since it gives some clarity and methodological purity to approaching this rather fuzzy concept, Janus-based concept, the constitutional identity. On the other hand, I have some problems with that for two reasons. First of all, indeed, a textual approach gives some clarity, but also it detaches the text from the context. And very frequently, we are gaining substantial information about the constitutional identity from the context itself, also from various sources of law. And second, what you mentioned about the Russian constitution and the implicitly this primacy of the first two chapters over the rest of the constitutional text, that's what is called constitutional polymorphism by some scholars. And in this case, if you approach not only the Russian, but if you have a comparative overview, you can see that many scholars can claim that what is called an entrenched clause or unamendable clause is actually containing the constitutional identity. And I strongly disagree with that approach. That's actually the approach of Professor von Bogdandy, which is justified in the German case, because indeed the Ewigkeitsklausel, the eternity clause of the German constitution, do contain most part of the German constitutional identity, but this is not the case in the rest of the countries. For example, in Romania, you have prohibition of federalism. You have the unitary state as a eternity clause, and that doesn't mean that the identity of the Romanian state is the unitary country. In Italy, it's the Republican clause, which is of course very important, but it doesn't exhaust the Italian constitutional identity. And in the country from which I come, Bulgaria, we have not unamendable but an entrenched clause, and it's rather broad. So it doesn't mean that exactly those provisions which are more difficult to be amended are really the provisions which contain or somehow shape, form, and give a glue on the identity. So that's what I wanted to say. Otherwise, I strongly agree that a textual approach could be a very logical, rational, but I'm not sure if it's if the shortcut is really the right way to where we are going. Thank you.
Thank you, Professor Bartlett.
Yeah, so just briefly on that is my proposal is we start with the text and the structure, right? That's the beginning point of understanding what constitutional identity is. Of course, I never say we don't look at context, but the key thing is not to lose track, because what I'm reacting against is some literature and some statements that constitutional identity is purely just about a conception of history or tradition that you view as being right. That's the concern I have. I think that view of constitutional identity is incorrect. My view of constitutional identity is we start with the text and structure. We say, okay, there are these principles that the particular kind of entrenched chapters themselves commit the particular constitutional system to, and then we engage with that in light of context. Right, and that goes to a question that I see Anna Johnson has asked, and how would the Procuratura play a role in this? Well, one way we could think of is that the Procuratura could be an important institution that actually could implement decisions of the Constitutional Court in a really effective way. Of course, implementation of Russian Constitutional Court decisions is a real problem at the moment. It's a significant issue that Sergei and others have worked on. In terms of getting actual implementation. So we can think of institutions that can kind of team up with the Constitutional Court. And we see that in other comparative contexts, Colombia, for instance, where courts rely on other institutions. So context can play an important role in building a system of adherence and engagement with fundamental universal principles that are committed to in the fundamental chapters, but so the context comes through that. And so I think on that, Martin, we might just disagree that I do generally think that when we start in text and structure, then we look at the kind of entrenched text first. That's just a logical step, and then we move. But it might be the case that there are other aspects of constitutional identity that are outside of that. But I think at least we start with the text and how the Constitution is structured, how it fits together, how it works together, and then work with context.
Thank you very much. I have another question from the chat, this time for Professor Gadjev. So the translators should probably translate this now.
Unfortunately,
Professor Gadjev, what do you mean by the systematizing core of constitutional law?
Unfortunately, Professor Gadjev left our session. Uwe, we do not hear you.
Then then we will simply continue with other questions. Any further questions? We have still time. I don't see any. Let me ask. I'm sorry.
Oh, sorry. There's also a question from Mathieu Bertrand, which has been translated from the French.
Yes.
With respect to what engagement means.
Yes. Should I just? Why don't you just answer that? We can all read it in the chat.
Well, I mean, if you've got a question as well, you can go ahead and ask your question.
Okay, I'll ask my question. Unfortunately, Bertrand, I had to leave as well. So my question is simply going back to your. You said you wanted to look at the text and at the structure. This to me is a little bit odd because it's a way of interpreting constitutions only by two means. It's a method of interpretation, but where does it come from? Is that your method of interpretation? Is that the Russian method of interpretation? Is that a generic method of interpretation? And you said that, for instance, there is a hierarchy between chapter 1 and 2 of the Russian constitution on the one hand and the rest. Is that truly part of constitutional law? Would all constitutional lawyers in Russia say, oh yeah, that's the way we see it? In Germany, we have the idea of constitutional identity as well. And we would feel a bit strange if somebody tried to impose of us such a limited method of interpreting our constitution. It's up to German, well, not only Germans, but it's up to German constitutional legal methods to determine what is the content and what is the constitutional identity of our constitution. So what would be your answer?
Okay, and I think this probably fits with Bertrand's question as well about engagement. So the approach that I suggest is a one that I think is actually general to the legal profession. So I'm making essentially a general claim about how lawyers make arguments in front of courts. And in particular, I'm saying that when we make arguments about text and when we say something like, I'm going to make a particular claim about constitutional identity, not national identity, not history, constitutional identity in front of a court, what we're doing is we are making a claim about that constitution itself. So we then need to, we start with the process of saying, okay, what does the text of the Constitution say? How is the Constitution structured? How do particular provisions relate to one another? And then we can move on from that. But we need to start with that. And I think that is a relatively, that is a kind of positivist way of understanding what constitutions are and do, is to say we start with text, we then move to structure, and then we think about context after that. But the fear I have about not taking into account text and structure as primary and kind of the motivators of formulating constitutional identity is that it suddenly then becomes, well, here's my view of what national identity is. It's grounded on a sociological theory that I myself, or a particular highly contested sociological theory or interpretation of history that people may or may not agree with. Whereas I think the advantage of my theory of a textual and structural theory is everyone agrees on the text. Everyone agrees that certain words are in certain places in a constitutional text. And everyone agrees that certain words are placed in structural relationships with one another as part of a written constitutional text. And that we can then at least have something to agree on when we make arguments about identity. And then we can then say, okay, well, Russia is in a particular system is committed to a series of higher norms that are highly entrenched, and we need to engage with those. And then we begin to understand how that plays out in particular contexts. And courts are doing that. But the key thing, I think, is at least in my argument, is to try to say is we start with that process of text and structure, because everyone agrees on that. Everyone agrees what the Constitution says. Not everyone agrees what a national tradition is. Not everyone agrees in a country whether we should take an obedient, should we just follow what history says, or should we change our historical approach to history? You know, there's obviously different positions we can take with respect to traditions. Traditions don't always just self-perpetuate, right? Traditions change, and they change because people say we want to do something different. And the key point I'm making about the Russian constitutional identity is that the Constitution itself takes a clear position on Russian history, which is that it wants to move away from the Soviet approach, right? Move away. So there's an idea of reforming Russian statehood, gosударственность, through an engagement with universal principles contained in particular kind of provisions that are higher, that are placed in entrenched positions. And by engaging with those, the court then is involved in a process of adapting these to different contexts. And of course, and part of that is determining what the Russian constitutional identity is. The Russian constitutional identity is one that is actually taking, I think, in that case, a transformative position, and therefore requires, as I suggested in my talk, a more active role for the court rather than a less active role for the court with respect to kind of individual claims or claims of rights and so forth. Because of course, the Constitution itself is itself committed to these higher principles in its fundamental provisions. Основные, fundamentals of the constitutional order. That's chapter 1. The first one is federal democratic law-based state with a Republican form of government. Chapter 1, Article 1. Article 2, the man, the individual and his rights and his or her rights are supreme. These are clear statements. And I think these should be, and they fundamentally should begin the beginning point of any discussion of constitutional identity. And my fear is that a lot of the discussions have kind of gone beyond that. So my methodological point here is we need to start with this. Thanks.
Okay, thank you very much. We are also drawing to a close now time-wise, but I think before we stop, we should give Professor Nakayama maybe a chance to make a short comment on any of the questions that have been asked or the answers that have been given. Please, Professor Nakayama.
No, thank you very much for.
Okay, thank you. So it is 2 o'clock, and there is not only human rights to constitutional identity, but also human rights to a coffee break. Although normally that means coming together and having and continuing the talk, which we cannot do here, but maybe we can do at a later time. I thank you all very much for attending this highly interesting workshop. I have learned a lot. We had 3 great speeches. We had interesting discussions. Everything came together. The only thing we don't have, we can't touch each other and really talk during the break. I hope that governments will at one point understand that they should stop these measures and let us be free again. Not right now. So please, I thank you again, and I wish you all a great continuing conference in which we will, of course, certainly all participate. Thank you again, and thank you, Sergey, for the wonderful organization.
Thank you so much. Thank you, colleagues.
Thanks, yeah, thanks, everyone.
Our next session will be in 1 hour, and it will be on the theory of constitutional identity.
In 1 hour, it means 4 o'clock Moscow time, right?
Yeah, right.
Okay, thank you very much.
Thank you. Thank you. Thank you, Uwe. And thank you, Will. Thank you, Cam. Thank you. Bye. Yeah, colleagues, we have to wait for a few moments for our chairman to join the session.
I am here.
Please start the session.
Okay, thank you very much. To begin with, I want to say welcome everybody. Salut à tous. On va commencer le panel sur la théorie de l'identité constitutionnelle. Well, for me, it's a privilege. I'm very pleased, very happy, and hope this conversation would be very thriving for all of us. Let me express my gratefulness for the IC Committee of the International Association for Constitutional Law, as well to the organizers, namely Sergei Belov, Anna Grichenko, and all the team. And I will, following the structure of the conference as it was planned, I think that it's high time now to explore which are the theoretical grounds. We are somehow summoned to delve into the makings of constitutional identity, though within a broader realm, I would say, the one that constitutional theory provides to tackle the issue. I propose a couple of questions, very simple ones, that perhaps may help to trigger some thoughts. Firstly, I think that would be interesting now to ferret around the idea of usefulness to come up with just a single notion of constitutional identity. Does it sound good or not? I wonder as well if there were harms in terms of analytical clarity in the wording is important, because as far as I am concerned, I found several linguistic issues when addressing the concept of constitutional identity. Finally, looking more diachronically, I think that would be interesting if we can try to make a clear-cut distinction in the dialectical interplay between traditions and local and political oriented insights that comes from the constitutional polity vis-a-vis the principles, values, and all of constitutionalism. Okay, having said that, I will make a very brief present introduction of who are this great line of speakers. We are absolutely happy and I'm very excited to be with such a great line of first-rate speakers. First of all, I will introduce, and we will be the first one to take the floor, Professor Gary Jacobson. He's a Malcolm McDonald. I have to read this, sorry. He's a Malcolm McDonald Professor of Constitutional and Comparative Law in the Department of Government, and as well as he's a Professor of Law at University of Texas at Austin. He's a renowned scholar. He has widely published on American constitutional identity, comparative constitutional law, and other compelling issues concerning the connection between politics and law. He has, to my knowledge, 2 major volumes that everybody should visit. Of course, the Constitutional Identity volume, Harvard University Press, 2010. And he has just recently issued a very provocative and interesting volume together with Professor Yaniv Rosnaï, which is labeled Constitutional Revolution, Yale University Press. The second in line is dear Professor Michel Rosenfeld, who is Professor of Law and Comparative Democracy. He's the Justice Sidney and Robbins Professor of Human Rights and Director of the program on global and comparative constitutional theory at the Benjamin Cardoso School of Law, Yeshiva University in New York. Well, Rosenfeld is an expert, well-renowned on comparative constitutionalism, constitutional law, constitutional interpretation, and to my grasp is that he's also a theorist, a political theorist who have worked very hard on the legacy of liberalism. He vastly published among his major opus. We can single out a seminal book I read a long time ago on constitutional identity and diversity, Duke University Press. I remember that. He compiled other research and essays on the subject. And very dearly for us, he was president of the International Association of Constitutional Law. Then, third in line comes Professor Martin Bellow. He's vice dean of the University of Sofia. He teaches constitutional and comparative constitutional law, comparative constitutional history, European constitutional law, and legal theory. And to conclude, in the end, we will have very pleased to have Professor Constance Greve. She is a professor and researcher both at Chambéry and University of Caen. She was a lecturer at the University of Robert Schuman at Strasbourg, being herself also a member of the Institut de Recherche Carré de Malbec. She's have a very important scholar record of books and scientific articles. So here goes the simple rules. We will stick to the program. First, to take the floor would be Professor Jacobson. Then we open the floor to questions, remarks, rejoinders. Just raise your hands. If you don't want, you're not willing to, you just go to the chat and write it down. I will try to convey those concerns and questions to the panel. That's all. Professor Jacobson, the floor is yours.
Thank you very much for that introduction. Keep within that time frame. At least that's my hope. Okay. The German Federal Constitutional Court's use the term constitutional identity in assuming a posture of vigilance in relation to any threats that might compromise the textually clear safeguards in the basic law. The court embraced the exercise of identity review as one of its central judicial obligations. The skeptics eager to impede the progress of further elsewhere in Europe a model for emulation. Became the occasion for pronounced unease about constitutional identity's harmful political potential. But these understandings were on a distortion of the concept's core meaning, which is what this is not today. The EU's constitutional identity as phenomenon of democratic backsliding. If an important objective of the Lisbon decision was the noble one of defending liberal constitutionalism, the substance of a democratic fundamental order, this original deployment was quickly created with less noble ends, namely the demise of that order. To the extent that the pursuit of these ends has facilitated the application of the constitutional identity idea, a reassessment of its value was entirely predictable. The evolving critique of constitutional identity needs to be addressed. However honorable may have been its argument by Dr. Tenko on defending liberal constitutionalism, the idea's appropriation that order's demise has understandably led to scrutiny of its conceptual usefulness. And so a distinguished jurist writes, quote, "It's time for scholars of constitutional identity to issue a recall on the dangerous product they release into the marketplace of ideas." And as one of the scholars to whom the recall appeal was directed, I think it's important that this critique be taken seriously. The disturbing manner in which constitutionally related identity renderings have been executed may be readily conceded. Still, before disposing of the concept, we might wish to consider that its best articulation does not necessarily correspond with its most problematic applications. Europeanist concerns over German efforts to constitutional barriers against threats to the nation's judicially affirmed self-identity
started elsewhere, most notably in Hungary, has benefited from the interpretive errors spawned by the earlier morally commendable exertions of the German court. A problematic static conceptual understanding, according to which identity is
discovered in text or history, has made it possible for compliant courts to avail illiberal and exclusive constitutional constitutions, however, acquire their identity through experience. This identity exists neither as a discrete object of invention, nor as we are witnessing in Hungary and other places, a heavily encrusted essence embedded in a society's culture, requiring only to be discovered. The German basic law, while not a legal constitution, is perhaps the most prominent example of a document whose core principled commitment is to secure the transcendence of the nation's past. The obscuring of this salient reality through its emphasis on the document's entrenched guarantees
led the German court inadvertently to provide others with a pathway to the past and with support for the prejudices of the present. So in these brief remarks, I can only make assertions and hope that they will lead to some productive discussion. So let me make several related points.
First, constitutional identity represents a synthesis of political aspirations and commitments that are expressive of a nation's past, as well as the determination of those within who seek to transcend that past. At least three possible constitutional paths follow
each with a significantly different take on the identity question. First, the founders of the Constitution could, in the German case, made clear that their determination to relinquish the document's ties to the past. That's one. The nation's distinctive history
as a backdrop to the new venture, but it was explicitly inscribed in the text, and the nation of the major component of history would henceforth provide make clear their determination to exalt a period in the nation's history as a foundation upon which to build a constitutional identity. As a conveyor of expressive content, the text itself would be of lesser importance than would the association's summon for
excavation of an imagined past. Three,
the text could invest it with a somewhat subversive significance, such that its future invocations would serve the purpose of altering the course of history by selectively uprooting those patterns of social experience that no longer comport with contemporary aspirations. Unlike one, in this model, the transcendence of the past remains a continuing constitutional project, entailing a transformative societal agenda that is more comprehensive in its ultimate goals than disavowal and negation. So, two are exemplified by Germany and Italy respectively. Illustrative of the third path is India. Thus, the Indian Constitution is in many respects a revolutionary document. That document's endorsement of a socially reconstructive agenda initiated a long democratic revolution, or in Nehru's words, a step-by-step progression towards validation of the Constitution's identity. Of course, today there's reason for deep concern that the leadership in India is committed to an agenda that will replace Nehru's path with one more suggestive of what we are seeing in Hungary and elsewhere, a path that is which turns back on itself rather than towards transcendence. Second, what has largely been absent from the judicial exercises in identity review by member states in the EU is an acceptance of conflict as an enduring aspect of the constitutional predicament. Implicit in this understanding of a nation's constitutional identity is a dynamic of dialogical development. Such an acceptance is no guarantee that applying the concept of constitutional identity will yield laudable outcomes compatible with the precepts of liberal constitution. However, is minimize risks associated with political ambitions incompatible with those precepts. The invocation of constitutional identity becomes deeply problematic when its derivation and application are managed in willful or careless neglect of the disharmonic reality that is endemic to the Constitution. Constitutional identity is concerning and in some cases dangerous when it is inspired by a need to eliminate contradiction or incongruity. Expunging dissonance from its core meaning enables guardians of constitutional identity to achieve a desired outcome without confronting the obstacles that would otherwise make the attainment more problematic. As Anne Applebaum writes, the noise of argument, the constant hum of disagreement, these can irritate people who prefer to live in a society tied together by a single narrative. Third, identity is an interactive process whereby a constitution, much like a person, develops its distinctive character or individuality through a within the broader context of its being. This comports with the philosopher Charles Taylor's insight. My own identity crucially depends on biological relation with others. The same relationship evolutionary possibilities in a nation's constitutional identity. Whether or not one agrees with how the substance of identity has come to be understood, that such an understanding may have assumed an unalterable, unyielding status in the course of judicial scrutiny betrays a fundamental misconception about the nature of the concept. So, a strong reliance on text and history can lead to a static representation of constitutional identity, thereby empowering those charged with its formal articulation to establish a fixed constitution. Or ignoble. Internal to a constitutional text, or between the text and the social context in which it is situated, that is the driving force behind a nation's evolving constitutional identity. A perfectly harmonious constitution is simply an illusion. So now just a quick take on how this is playing out in Germany and Hungary. The German court's cautious approach to European integration in Lisbon, if not so much in later decisions, included an unfortunate foreclosing of a dialogical process of judicial and political interaction. Such a process presumes the inherent mutability of constitutional identity. According to the court, quote, the constituent power of the Germans, which gave itself the basic law, wanted to set an insurmountable boundary to any future development, end quote. Entrenchment epitomizes the new constitutional reality. But it is illusory to isolate a specific identity, Germany's, from the larger European historical narrative of which it is a part, and believe that it will or should remain unaffected by the connection. It should not be thought that once revealed in a text, an identity, in this case, the German constitutional identity, simply is what is therein stated and must be preserved as such. Rather, it develops over time, which is to say it is not an entity inhabiting a constitutional text, there to be found and maintained as is by those to whom it applies. The basic law's eternity clauses are a starting point for constitutional dialogue, not a textual endpoint for juridical safeguarding. However, in designating itself the instrument of identity review, and by embracing a fundamentally static textual interpretation of constitutional identity, the continent's most powerful national court became the institutional epicenter for assessing the precise character of supranational respect for indigenous constitutional essentials. As such, it has also become a source of emulation for other national courts. Alas, some of them care less than the German judges about the primacy of their constitutional text, and at least as much about the rewards of constitutional identity. Case in point, Hungary. The Fidesz leader charged with drafting the new Hungarian constitution said at the time, quote, a constitution defines a country's identity. It condenses what we think of our history, achievements, attainments. Hungary's previous constitution, he said, did not fulfill this function of defining the nation's identity. But unlike in Germany, as the Hungarian court's 2016 refugee decision makes clear, the constitutional text plays a decidedly diminished role in discovering constitutional identity. Quote, the court established that the constitutional identity of Hungary is a fundamental value not created by the fundamental law. It is merely acknowledged by the fundamental law, end quote. The national avowal's exaltation of the historical constitution may, as was said on the court, generate an uncertain methodology for those charged with the protection of Hungary's constitutional identity. But if, in accordance with the avowal, future generations are, quote, to make Hungary great again, end quote. That sounds familiar from where I'm speaking. It will happen as a result of the recognition, quote, of our country as a part of Christian Europe 1,000 years ago, end quote. If this does not create an insurmountable boundary to future development, it surely establishes a restricted pathway in which the past serves as a more or less fixed marker of constitutional legitimacy. Now, while the national avowal includes ample historical allusions to a past that comports with contemporary illiberal ambitions, Constitution. For example, it declares, we hold that human existence is based on human dignity. In so doing, it aligns the Hungarian text with similar sentiments inscribed in the governing documents of both Germany and the EU, which presents us with an obvious question. Why should we not, as of course we do in these other jurisdictions, expect the Dignity Declaration to push Hungarian legal outcomes to a constitutionally liberal destination? And does not the textually disharmonic language of the dual commitments promise a dynamic interpretive framework for delineating constitutional identity? Here again, the German precedent is important. The unamendable provision that elevated dignity to its inviolable position within the basic law's objective ordering of values led the FCC to conflate the affirmation of constitutional identity with a defense of national sovereignty. The eternity aspect codified in Article 1 established a clear and immutable core whose safeguarding was to be the principal responsibility of the Constitutional Court. If there's a concern in any of this, it lies not in the commendable exercise of identity review or commitment that is constitutionhood. Rather, potential lost opportunities to refine the meaning of dignity by not engaging dialogically with extra sovereign authorities whose own commitments to the same principle are almost surely sincere. Indeed, dignity's perceived scope and significance are not the same in all legal systems. A formal acceptance of dignity is no guarantee that its substantive meaning will resonate in comparable ways across borders, or even within them at different times, such is prominently the case in Germany. The dual histories of Kantian and Catholic thought have come to shape and define the concept, sometimes as competitive traditions with contrasting policy and, for example, and sometimes in ways that converge to a similar place. With regard to the project of supranational legal development and the basic law's declared openness to the advancement of European integration, the evolution of identity-laden provisions ought not to be isolated from parallel efforts in the broader community. Yet the text's enhanced protected status for particular guarantees may actually impede their subsequent substantive enhancement. To see in the unentrenched aspiration for human dignity in the Hungarian fundamental law reassurance that it will yield a salutary outcome as it interacts with the ethnocentric sections of the national avowal is simply unrealistic. It underestimates the potential of the document's historic constitution to define dignity in a manner consistent with an illiberal constitutional identity. It's not that the textual provision respecting human dignity is to be rendered null and void. Instead, from an extra textual source that is both. What happened in Germany can be understood as the replacement of a brutally anti-egalitarian idea of dignity, in which social honor is owed to an ascriptively defined class of people, with one emphasis equality and human rights. The reliance in Hungary on an exclusivist historical narrative to delineate a constitutional identity threatens to install a version of that older account into the heart of Europe. So let me just conclude very quickly. All constitutions are crafted over time in the sense that their meaning and identity evolve gradually in ways determined by a dynamic impelled by their internal tensions and contradictions, and their confrontations with a social order over which they have limited influence. In time, a constitutional order is constructed and shaped, and the ambitions inscribed in or attributed to the Constitution or not, or more approximated or lesser degree. In reflecting on Article 4, Section 2 of the treaty, Anita Schnecker has perceptibly written, and I quote, "Collective identity is, in the first place, not a static identity, but rather an imagined and constructed one. As such, it is also accepted that a homogeneous group is not a necessary precondition of national identity." And writing more generally, Francis Fukuyama has argued that the remedy for identity abuses is not to abandon identity. Rather, quote, "It is to define larger and more integrative national identities that take into account the de facto diversity of existing liberal societies," end quote. Unfortunately, these valuable insights have in recent years often not prevailed in the workings of some European courts. The derivation of constitutional identity has increasingly come to neglect sources of meaning that diversity, and fluidity. Prior to becoming one of these identity abusing courts, the Constitutional Court of the Czech Republic perceptively grasped the essential character of constitutional identity. In its Lisbon I decision, it said of the member states' court's relationship to the EU that it, quote, "should continue to be a dialogue of equal partners who will respect and supplement each other's activities, not compete with each other." In a modern democratic law-based state, state sovereignty is not an aim in and of itself in isolation, but as a means to fulfilling fundamental values on which the construction of a constitutional law-based state stands, end quote. The court's view of fulfillment, as Caitlin Dubias has astutely observed, entails a procedural understanding of constitutional identity that allows for its continuous rediscovery through dialogue that maintains its legitimacy. Such an understanding is commensurate with the more constrained account that may follow from the lofty heights of a formally unbending text, or the exploitative historic validation of contemporary parochialism. Thank you.
Thank you very much, Professor Jacobson, for this inspiring presentation. I give the floor to Michelle Rosenthal. Please take the floor.
Thank you very much, Pablo. It's a pleasure to see you, even though we're only electronically seeing each other in 2 dimensions instead of 3. I also want to thank the organizers of this roundtable for having included me. I was very interested in following Gary's presentation, as both he and I have worked very long on the concept of constitutional identity. We have different views. I'll start by picking up on one of the things that Gary said at the beginning of his talk, which is that there are people who said that people like he and I've been working on constitutional identity now for almost 30 years, that people and I should sort of withdraw the term because it has done more harm than good. That reminded me of the freedom that existed in the People's Republic, since Gary spoke of Germany. One of the most repressive regimes we had before the fall of the Berlin Wall. And so a lot of the great terms that, when the great concepts that we have are hijacked and misused, and it obscures what those of us who are working on this for a long time certainly were looking into it. So let me, with that, having said that, backtrack now and try to respond to Pablo's initial question. Is there one concept of identity, a constitutional identity? And my answer is no, because constitutional identity is found in many different ways. Constitutional identity, to begin with, should be distinguished from national identity. One of the questions that we had before we came into this current wave of populism throughout the world was, would there be a sufficient constitutional identity to uphold the European Constitution that everybody thought around 2004 was about to come into place, but then those who remember that far back, the French and the Dutch people voted against it, and it went by the wayside, although many of its elements have nonetheless inhered in the European Union. And since then, obviously, it has had its ups and downs. So that would have meant the constitutional identity, if it worked, and if ever it will work, that is transnational. And so constitutional identity as a concept is necessary because the Constitution creates something among those that are subjected to it, and starting with those that make it, that is different than national identity. And national identity, as Benedict Arnold told us, Benedict Anderson told us, Anderson, not Benedict Arnold, Anderson told us, is the question of an imagined community. And constitutional identity should be viewed the same. It's an imagined community, but it is different than the national community. And one can imagine a lot of, the United States in this sense is, I think, unique, because I think its national identity is tied into its constitutional identity. After all, the Constitution of the United States in 1787 started with the idea of we the people, which was a pretty empty holder to the extent that it excluded most of the people living in the United States then, like obviously slaves and women. And because the United States is a country that was developed through series and waves of immigration, its people was mainly in the future. On the other hand, one can imagine that Germany, France, Russia, many of these countries that have a very, very long millennial existence did not have a modern constitution for a lot of their history. And one could easily imagine them shedding their constitution and still have a continuity, an imaginary that goes back to the French, to the Gauls before the end of the Roman Empire, et cetera, et cetera. And you see that an identity, an imagined community could prevail through all kinds of different regimes. So in this sense, constitutional identity has to be distinguished from national identity, although the two of them have a lot in common. Let me just get another thing out of the way, and this sort of simply is in tangent to what Gary was saying, and that is in the European Union context, the development of constitutional identity, as if I would call it, a hard legal concept, as opposed to trying to understand how constitutions work, how they relate to the society to which they're attached. Why is it that the United States free speech conception is so much broader than that of other countries? Why do we, for instance, tolerate hate speech, whereas in Germany it can be criminalized? All of these things can be explained in terms of different history, but also different constitutional identity. Judges in Germany feel comfortable criminalizing Holocaust denial. Judges in the United States have never done that and have been unanimous in saying Holocaust denial is free speech that is protected. So I find that the idea of constitutional identity is necessary to explain that difference, that you can see it's a whole concept. It works through interpretation of the Constitution, but it also works at the level of constitution making. And coming back to the technical, legal aspect of which I'll just mention, then I'll move on to the rather much more concept. The technical legal aspect is that at some point, the European Union and its treaties, its constitution first, but then its treaties recognized that there was a tension going all the way back to at least the Lange decision in the 1970s between the German courts saying, wait a second, all the European treaties are fine, but if it violates our constitution, then we cannot accept it. And then this became integrated into the European treaties to allow for countries to say, here is what's essential about my constitution. Here is that which without we cannot keep the integrity of our constitution intact, and we're going to call that constitutional identity. I remember once a French scholar, Michel Tropper, telling me that for France, that means the sovereignty of the Republican way of, that doesn't mean you cannot have international treaties and work together with other countries in the European Union, but it's sort of a core Republican idea. And for French, laïcité is something that is non-negotiable. So this is the French constitutional identity from this technical point of view. I want to move beyond that, because for me, constitutional identity permeates the realm of the Constitution and the relationship of the Constitution with the Constitution maker, those who are subject to the Constitution and the interpretation of the Constitution. And I view this, Gary mentions dialogic, and I agree with that, but I call it dialectic. It's always in conflict. And it is in conflict because constitutions are started usually as an act of rebellion and of negation. If you look at the 18th century, the great 18th century constitutional developments, the beginning of liberal constitutionalism in both the United States and France, they start by a very explicit negation and rejection of what was before. In France, you got rid of the whole feudal system and started the idea of the Enlightenment, equality, basic equality, of course, with a lot of flaws. Women were not included, etc. But I mean, at least ideologically, the launching of the French constitutional revolution of the late 18th century was in part to get rid of the past and the status quo ante, and then to have to build something new. The same is true in the United States. We had to overthrow, and it's interesting when you look at the Constitution of the United States, the interpretation given, the provisions in the Constitution, in part, it's very clearly a negation of the British system. You cannot have titles of nobility in the United States, so you start rejecting the whole feudal system. And then, of course, when you look at justices of the Supreme Court interpreting the Constitution, they want to look, what does due process mean? Well, we go back to English law and see what a due process means. So what I want to concentrate a couple of things. One is that I want to speak about what is the liberal or any constitutional identity. How does it function? It's a dynamic. I define constitutional identity because in most cases, you cannot make a new constitution without an act of negation, of rejection. Now, of course, you can have certain constitutional changes that are more, even though it's a new constitution, they're more like amendments and they preserve most of what was before. If you look at France's history with its, I don't know, 15 or 16 constitution, to some extent, there are changes that I would say involve negation. To others, they just involve incorporation. We still have today in the 1958 Constitution references to the preamble of the 1946 Constitution. We have references to the 1789 Declaration of the Rights of Man and Citizen. So not every new constitution is a revolution, but the act of having a new constitution does contain an important aspect of negation. So that means that you start, constitutional identity starts as a lack, as something that has to be constructed. And depending on where we are, this construction involves different aspects to it. And I have said in looking at both the construction and then the interpretation of the Constitution, which leads to evolving concepts of constitutional identity, it's not a static concept. In this sense, I think Gary and I agree fully. It is one that develops. And I have said that there are three main interpretive tools that are used in order to create a constitutional identity and then to change it, to challenge it, to fight over it, et cetera, et cetera. One is negation, and the other two are metaphor and metonymy. Metaphor is a way by which it's based on modern linguistic theory that is inspired by Freud's interpretation of dreams, which Freud calls condensation, which means that you pull things together in order to create at least an apparent unity that is important when you are dealing at the constitutional level. One example of metaphoric thinking was the development, and I'm thinking now of the United States, but this can be probably vindicated in other societies, the question of women's equality. And at least in the United States, our constitutional provision on equality, the Equal Protection Clause, says nothing about who is included or who is excluded within that clause. And for a long time, it was interpreted narrowly as saying that it was race was included because it came after the Civil War, but then race was interpreted in a very narrow sense because it meant civil and political rights, but not social and economic rights. That justified apartheid for a long time in the United States. But finally, in around the 1970s, the court turned to men and women and changed its jurisprudence. And it was a lot through metaphor, what I called metaphoric thinking, because it was the idea of, wait a second, men and women work. They're lawyers, they're doctors, etc. Why? What's the difference? There was a notion in a societal practice of paying women less or rejecting the qualified women from having jobs, et cetera, et cetera. So all of a sudden, this changed. And the arguments that had to be made was men and women are the same. There is a similarity between them that is much more important than whatever difference there are between the sexes when dealing with issues of employment. That's an example of metaphoric thinking. The other one is metonymy. You have to, and that deals with difference. So there's the constitutional identity creation has to be around, we're not this, we're not that. And when an example of the negation was given when we had a debate in the optimistic days of 2003, we had a major conference with scholars from many parts of the world, including many Europeans who were very keen on the coming constitution for the EU, which, as we know, did not materialize. And there were discussions about what kind of identity would this constitution have? And there were many different iterations of it, but one of it was, we're not like the United States. We're not a thoroughly individualistic, capitalistic, without limitation society. We have much more of a social welfare view. And in this sense, the countries within the European Union have at least a negative relationship to the identity of the American people. And that'll be embedded in our constitution that will bring us together. So here is an element of negation. And now metonymy is how do we deal with a difference? And this is important in the Freudian origin of this idea of metonymy, which has to deal with difference and contiguity. What happens is you have to hide something. And here, for instance, some constitutional constructions have to downplay certain things. So if you have a country in which there are troubling religious differences and conflicts, you may want, or ethnic differences and conflicts, you may want to prohibit political parties along religious lines or along ethnic lines. So you somehow have to displace the problem, which would possibly make the constitutional project eventually fail, and try to use the Constitution. And by the way, this is an example where constitutional identity may differ greatly from national identity, because it may be that this nation is characterized by hundreds of years of religious wars and conflict between the two main religious groups within the country, and you try through a constitution to minimize, to pull the attention somewhere to try to mitigate that difficulty. Now, we have an example at the level of interpretive, using that judges interpreting the Constitution. We have the major case that is the foundation of the entire personal liberty, privacy reading into the Constitution of the United States. There's no explicit provision to that effect, but it was a case in 1965 called Griswold versus Connecticut, which led eventually to Roe versus Wade, which is the case that said that there's a right to abortion under the US Constitution, which is now under attack. But the first case, the Griswold case, is interesting in this sense because it decided that family and personal and individual privacy, although there's nothing in the Constitution, we should look to historical tradition. Now, the case itself involved the criminalization of use of contraceptives, a law in the state of Connecticut that prohibited the use of contraceptives even among married people. Now, it's a great case of metonymy or displacement in the following sense. The court majority said, this is a great tradition in the 18th century, which even precedes our Constitution, that marriage is something that the state and government should not intrude with. The privacy of the marital couple should be respected, and we continue with that. But if you notice, what was at stake in the Griswold case was contraception. And no one can, I think, seriously argue that in a deeply Christian society of the 18th century, the connection between marriage and the use of contraceptives was established. Quite the contrary. If you read Locke, for instance, as an example of a relatively liberal philosopher of the 18th century, he makes it very clear that the purpose of marriage is for procreation. So here is an idea that you have rebuilt the tradition by using this device, this interpretive device, which I call metonymy. So I can't go, because obviously my time is limited, into more details and subtleties about this, but I think it gives you enough to show you that we're dealing with a concept that is essential, constitutional identity, that is dialectically and dialogically engaged and is in constant, needs to evolve constantly to adapt to the necessities of the society and of their constitutional day-to-day existence. I want to end my talk with a brief reference to the new populism. And here, Gary made my life very easy because he spoke about Hungary. Populism is interesting because it changes the national and the constitutional identity. And the question really for me is, at what point does a populist, illiberal society, in a certain sense, move away from constitutional identity? My point is this. A purely authoritarian, if you take Orban's evolution, and he often said, I am a democratic leader, I believe in the Constitution. By the way, it's very interesting to see that, for instance, Orban was able to get most of the changes that gave him more and more power through constitutional means, whereas his neighbors in Poland were not able to do that. They did not have the type of majority in the parliament in Poland. And so many of the changes that were initiated by Kaczynski were technically in violation of the Constitution. They used the law, they used the parliament, but they could not really amend the Constitution, get a new Constitution, because they did not have the requisite majority. Orban, on the other hand, did have the 2/3 he needed in the Hungarian parliament. And so he changed the Constitution. Not only did he adapt the 2011 Constitution to replace the previous one, but he also then amended it, and each time he got a lot of power. I don't know when the turning point, whether it has or has not occurred, where Orban goes from an illiberal constitutional leader to perhaps one in which the Constitution becomes a facade and an excuse. Many have claimed that when he took the power, well, the parliament gave him potentiary powers, basically during the COVID crisis, that he crossed the line. But I'll leave that aside. But until the Constitution still functions, even though illegitimately, there is clearly a change in identity that goes from the liberal to the illiberal. And populism is defined by reducing the people to a part of the people. So the first move of populists is to say the people are, and usually to get one example of right-wing populism, are the common person is the people, the elites, and those who maybe the wrong religion, would be immigrants. Those are no longer part of the country. The move in Hungary from the previous constitution that was a constitution of the people of Hungary to the constitution of the Hungarian people, which means the ethnic Hungarians, is a very big move in two senses, because Hungary has minorities within its borders, like the Roma, who are not Hungarian and ethnic. And also there is a Hungarian ethnic population in Romania, Slovakia, et cetera, and there've been many tensions between these countries because there's been a tendency in Hungary, they have not forgotten the pre-World War II world, in which the greater Hungary in the Austro-Hungarian Empire was much bigger than what it is today. So you have an idea of constitutional identity, which is wedded to national identity, ethnic belonging, which is a shift from the liberal to the illiberal. I'll close with my own country, because Trump had a similar idea that the people of the United States is not the entire country. Trump, for instance, called the press the enemy of the people, and several times says that Democrats are un-American. And he ended his presidency with the war between the experts, this is during the COVID crisis, versus the common people, the Republicans, the real patriots, et cetera, et cetera. So there is at some level an idea of redefining who the people is, and that needs, so long as constitutional order continues and we don't go to pure authoritarianism with the Constitution is a mere excuse, it requires a redefinition, which people who are wedded to liberal constitutionalism will find very unfortunate. But that doesn't mean that the concept of constitutional identity is still not working, at least till the point in which authoritarianism is fully established in any of those countries. Thank you very much.
Thank you very much, Michel, for this excellent presentation. And I swiftly give the floor to Professor Bello.
Thank you very much, Professor Ribéry. I would like to say that it's a great pleasure and honor for me to be part of this excellent event. I would like to thank Professor Belov and Professor Gritsenko. Спасибо большое для приглашения. Thank you very much for the invitation, and I'm especially flattered and honored to be part of this remarkable group of scholars who actually have drawn the major lines in the debate. And this is rather challenging for persons like me who had to add up and step on the shoulders of giants. So having said that, I have to be fast and furious because time is running. And I will just briefly give you a glimpse of what I would like to say. Actually, so far, a lot have been said about what is constitutional identity. So there was a lot of conceptual analysis, some case studies, some discussions, some comparisons with other possible forms of identity. So in the first part of the conference, we have seen a textual approach, which is quite proper. I do not share it because I have to admit that I'm a socio-legal scholar, but it has its proper justifications. Although, as I said also in the previous panel, I do not share so much this textual approach. Although it has a lot of advantages in terms of clarity, you can have arguments based on the entrenched clauses, unamendable clauses, based on the case law of the courts. But the problem is that, first of all, many constitutions do not have entrenched clauses. Most of them do not have unamendable clauses. And second, the unamendable clauses and the entrenched clauses are not necessarily containing identity. Sometimes they are containing the evil. They are containing their taboos. They are forms of constitutional tabooing. They are examples of fear, of the mythology of fear. And that's why I prefer the social legal approach, which is, on the other hand, rather fuzzy. So we come up with a kind of, how do you say that in English, a devil's circle, like vicious circle, because we're operating with a concept which is very powerful. It is like a powerful weapon in the hands of the politicians and the courts as well. But on the other hand, we don't have much of a consensus what is actually constitutional identity. And coming from European background, I have to tell you that my presentation for the remaining 18 minutes, which I have, will be focused on Europe for two main reasons. First of all, this is the region which I know most. And second, because actually constitutional identity has been the concept and the tool and the instrument which was most useful or most dangerous exactly in the European continent. Because for other countries, it might be very interesting debate, how it relates to the constitutional tradition, to constitutional core. But in Europe, it was a power game. And I have to admit that constitutional identity is a genus-based concept. It has legal phase and it has a political phase. And I strongly believe that the political core of constitutional identity prevails over the legal core. And the judicial dialogue that follows is actually something like dribbling in the center of a basketball playground, compensating the lack of political vision and clarity, what happens with Europe in constitutional terms. And in that regard, I want to say that I want to allocate the debate on constitutional identity especially in the context of the European Union, within three main archetypes of constitutionalism that I'm trying to work on and develop. And these are what I call Westphalian constitutionalism, post-Westphalian constitutionalism, and neo-Westphalian constitutionalism. So what I wanted to demonstrate is what does constitutional identity serve for from the perspective of these three main theoretical paradigms, which have also important and vast political implications, and which are actually practiced, have been practiced, or will be practiced in the near future. So this makes me briefly outline the main features of these three main models, namely Westphalian, post-Westphalian, and neo-Westphalian constitutionalism, and give you a short overview and glimpse on how does constitutional identity function, or is supposed to function within these conceptual paradigms. Well, Westphalian constitutionalism, I chose that term not because I have fixation on Westphalia, but because the term modern constitutionalism is rather dubious and broad, and the term postmodern, which might be an antipode, has been criticized as too much bound to literature and other humanities, and thus not being appropriate for a real legal analysis. So Westphalian constitutionalism is what we broadly define as modern constitutionalism. And this is a constitutionalism which is based on one important ordering matrix of its constitutional geometry, and that's a hierarchy. Hierarchy in legal sense, resulting in supremacy of the constitution, hierarchy in political sense, resulting in ultimate, absolute, holistic versions of sovereignty, the way they have been defined by classical authors such as Hobbes, Rousseau, and so on and so forth. Other important features of Westphalian constitutionalism are closed statehood, right? So the state is conceived as what Neil Brenner would call a territorial container, aiming at full match between people, population, and power in the terms of Jelinek. And the constitutionalism there is a hierarchical phenomenon derived from the supreme ultimate power of state. So this is very, very fast, very brief outline of what Westphalian constitutionalism is, and you can imagine that this was the concept that was conceived at the beginning of the early long 19th century in the terms of Hobsbawm, and which was supposed to become more and more fragile after World War I, and began to be downgraded, especially in Europe, in the course of the European integration. The second model, which seemed to be aiming to mark the end of history in the liberal terms, in the terms of Fukuyama, was the post-Westphalian constitutionalism, and this was not only theory but also phase in the development of constitutionalism, which spread, broadly speaking, from the end of the Cold War, and unfortunately, I would say, until this very unfortunate decade, which we have experienced, facing multiple crises, starting with the financial crisis, going through migration crisis, and ending up with the COVID-19 pandemics. So this model was based on open statehood. It was based on global fluidity of the demos. We have experienced the emergence of what Manuel Castells would call space of flaws. So the territorial container of the state was not only legally decompressed by, for example, clauses in the constitutions that admit the primacy and supremacy of international and supranational law, but also it was dehermetized through these flaws that marked what Saskia Sassen would call transversally bordered spaces, flaws of information, of financial capital, of migration, and so on and so forth. And also the concept of open statehood was further developed, especially in Europe, especially in the European Union, because Europe was, to use the Neurath metaphor, a ship which has to be built in the sea. So it was a concept that was constructed in the course of running towards different goals. And coming back to the playground metaphor, constitutional identity was that instrument that was both shield and sword, or at least it was conceived as a shield and a sword, that could allow the protection of the core, the value core, the institutional core, the traditional core of the domestic constitutions, while allowing also for the opening of statehood and for the relative primacy of the European Union law. Unfortunately, these developments were interrupted by these multiple crises which we have experienced, and by the cracking in what Joe Weiler calls Pax Americana. So now we are witnessing this entry into the new Westphalian phase of development, where you can see the big clash between extremities, ideological extremities, between not only diverse but also antipodic models for structuring and organizing of public power, some of which trying to regain territoriality, regain national autonomy at its full scope, while others trying to further promote globalization. And in that context, I believe I have some 5 or 7 minutes to conclude. I would like to outline, to finish with the functions performed by constitutional identity in these 3 main models for organization of the world in general and of the European Union in particular. The Westphalian model is actually exemplified by what is largely defined as illiberal democracies or authoritarian constitutionalism, right? So it's much more as a tool for building a Chinese wall, for encapsulating the countries, and for protection against supranationalism, internationalism, for protection against these twofold processes that were unfolding in the last decades: the internationalization of constitutional law and the constitutionalization of international law. Clear examples are, of course, Hungary and many others, not only in Europe, but also elsewhere, like you quoted the United States in the time of Trump. So that policy, America First, was a kind of American version of what has been done in some Visegrad countries and beyond. The second, if we look towards the post-Westphalian usage of constitutional identity, it was actually a constitutional identity in that case was a tool for gradual achievement of opening of the constitutional orders of the member states towards the primacy of EU law. Because the European countries had to choose between the 2 extremities, the absolute supremacy, the absolute primacy of EU law, and the absolute supremacy of their domestic constitutions. And both of these alternatives were unachievable from political viewpoint, from historical viewpoint, from the viewpoint of constitutional anthropology. So the European Union, being a project in the making, was preconditioned upon this tactical use of constitutional identity as both safeguard of sovereignty and promoter of a post-sovereign order within the European Union. And that interplay was very dynamic. It brought to inconclusive results. So if we have to ask ourselves whether we have achieved more using constitutional identity or whether we have lost much more in Europe, I would say that's this question is comparable to the question whether the moon is far away from the Earth. Depends where you look it from. Well, if you look it from the perspective of Rome in comparison to Paris, the moon is really far away. But if you compare it to Jupiter, it's right behind the corner. So I would say that there was a potential of constitutional identity to serve as this partial remedy, partial replacement, alternative concept to sovereignty, but from certain point onwards, and I would agree with Professor Rosenfeld that it's very difficult to determine which was that point. And of course, there were many points in many countries, so it was asynchronic process, counterpunctual process. So this process led to this reversed use of constitutional identity in the emergent New Westphalian context. And since we may expect that the recent future might be New Westphalian, meaning a combination between supranationalism, internationalism, and new sovereigntism, new nationalism, a world looking like a Kandinsky painting, a world based on clear hierarchies, on supremacy, but also on circles, networks, and fuzzy concepts. I believe that these two concepts that are strongly interrelated, especially in the European Union case, constitutional identity and judicial dialogue, are difficult to predict what in terms of their outcomes and their functions, because they perform multiple functions. They perform legitimacy function, they perform opening function, linkage function, delimitation function, and also ideological function as well. But what unites this functional catalog is that these functions are really allocated on the edge between the domestic and the supranational constitutional orders within the European Union. And I don't have time to expand there, but they have a lot of promises to make, but also there are a lot of deficiencies related to many of these functions. So this is a very brief outline of what I wanted to share with you. I don't want to spare much more of your time, and I want to finish here. Of course, I'm open to questions, and thank you very much for giving me this opportunity. Thank you.
Professor Belov, thank you very much for your sound presentation. Now we move on with Professor Rev. Please take the floor.
Thank you. Can you hear me? Yes?
Yes, we can hear you.
Thank you very much. Thank you very much to the organizers for the invitation. I'm very honored by this. And I was very happy also to hear all the precedent interventions. I will focus for my part, on the constitutional identity as part of European constitutionalism or national specificity. That shows you that I also will focus my intervention on Europe, not only Europe, but more precisely the European Union. I would like to show how this constitutional identity functions in the relationship between the European Union and the member states, because it is in this context that the question of its qualification as part of European constitutionalism or as purely national specificity comes to the fore, because the answer to this question largely determines the legal assessment of this quest of identity. National or constitutional identity, thank you very much, Mr. Rosenfeld, for your developments on this subject matter, has recently been recognized by Article 4, Paragraph 2 of the Treaty on European Union, which obliges the Union to respect national identity, the equality of member states, and the fundamental structures inherent in their constitutional systems. As part of the primary law of the European Union and within the jurisdiction of the Court of Justice of the European Union, Article 4, Paragraph 2 appeals both to the law of the member states, which can propose a definition of their identity, and to the law of the EU, as ultimately interpreted by the Court of Justice. Whether constitutional identity is part of European constitutionalism or a purely national specificity raises, of course, the question of boundaries. How far do the requirements of European constitutionalism extend, and how far can the specificities of national systems be extended? Constitutionalism traditionally is defined essentially around the principles of democracy, rule of law, and the protection of human rights, and this today at the national, European, and international levels. The consensus on these constituent elements of European constitutionalism does not, however, preclude divergences as soon as one moves from the principles to their implementation. National constitutional identity then reveals its fundamental ambivalence and its diverse potential. At the same time, an integral part of European constitutionalism and a specificity of national systems, it is sometimes at the service of the dialogue of judges or of international cooperation, and at other times at the service of national demands, populist or authoritarian drifts. In recent years, the ambivalence has found its most complete theoretical justification in constitutional pluralism. This will be my first point. However, tribunals, in this case, especially constitutional courts, rarely allow themselves to be confined to legal theory. Therefore, constitutional pluralism cannot account for the entire range of judicial discourse. It is also necessary to take into account the contrasting judicial strategies. On the one hand, there are strategies that make use of European law and thus conform to European constitutionalism. On the other hand, strategies emerge that proclaim specifically national identities without much regard to the European positions. Can they be justified in the name of constitutional pluralism, or do they amount to a violation of the European values? This will be my two other points. So to the first point, constitutional pluralism as a theory of constitutional identity. Constitutional pluralism has made it possible to cast a doubt on the reality depicted by the classical theories of monism and dualism. The success of this theory is thus largely due to its descriptive performance. However, far from replacing classical theories, constitutional pluralism has been criticized both by the followers of classical theories and for its prescriptive aspects. So first to the success story of constitutional pluralism. Since Neil McCormick's article analyzing the German Constitutional Court's Maastricht decision in terms of constitutional pluralism, the latter has gained many followers and has thus multiplied and diversified into a multitude of different theories. Their common feature is that they consider the different legal systems as essentially horizontal, egalitarian, juxtaposed or coordinated, without a rule of conflict or a final word. The famous question of competence of the competence thus remains suspended. Many proposals, however, have tried to bring order to disorder and to seek mechanisms for conflict resolution, whether through meta-order or homogeneous values. Theories of the composite constitution or multi-level constitutionalism are also part of this. In these theories, EU law should in principle have primacy, but this priority may be denied when it clashes with fundamental national principles or values such as constitutional identity, in which case the primacy becomes relative. So the idea of hierarchy is not absent in these theories, as the systems appear to be partially superposed. The growing enthusiasm for constitutional pluralism has been met with increasingly vigorous criticism. The most classic one is that of the absence of mechanisms for settling conflicts, described by some authors as a sort of abdication of the law in favor of politics. In addition, the dangers of constitutional pluralism, which have been quoted by Mr. Jacobsen, these dangers consisting of the fragmentation of law and the possible inequalities between member states are underlined. These criticisms have become more acute in the wake of the German Constitutional Court's judgment on the European Central Bank on May 5th, 2020. In particular, the German court is criticized for opposing the binding force of European Court's ruling. Finally, some critics tend to equate constitutional pluralism with constitutional identity, which seems somewhat reductive. In view of these praise and criticism, the question remains as to how the constitutional courts have positioned themselves in these debates and how their strategies could be qualified. So I am coming first to the strategies which are in accordance with European constitutionalism. In order to comply with European constitutionalism, it seems necessary that the courts take into account the articulation inherent in Article 4, paragraph 2 of the EU Treaty, that the fact that the Court of Justice has a say in the proposals that may be addressed to it. In this respect, strategies that plead the case for identity in relation to union law appear to be in line with European constitutionalism from the outset. The Italian and French examples illustrated. The procedural consequences are identical in both situations. As to the Italian example, in the famous Tarico case, the Italian Constitutional Court refused to oppose the reservation of constitutionality based on respect for the Italian constitutional identity to the Court of Justice judgment. It prefers the path of preliminary request. The Constitutional Court invited the Court of Justice to clarify several provisions of EU law, in particular the principle of legality, which is also enshrined in the Charter of Fundamental Rights. These questions asked by the Constitutional Court establish a link between the constitutional law and EU law by clearly emphasizing the common constitutional traditions rather than the Italian constitutional identity, which therefore plays a secondary role in this argument. The court thus does not evade the conflict, but instead of engaging in a war of the judges, it tries to build a new balance with the Court of Justice, a new conciliation between diversity and unity, which the Court of Justice accepts. Another example is the French one. In the case law of the Constitutional Council, there are few references to legal theory. In respect to the relationship with union law, it mainly refers to the cooperation between sovereign states, the supremacy of the constitution in domestic order, and the integration of the EU legal order into the domestic law. Only the latter evokes pluralism, while the first two suggest a moderate dualism. As for the constitutional identity, it is recognized by the Constitutional Council, but neither its nature nor its content is defined, and this for good reason. In its only preliminary request, the Constitutional Council implements a strategy of subsidiary identity. Far from stating from the outset that the absence of of an appeal against the European arrest warrant contravenes the constitutional identity of France, the Council asks more concrete questions of the Court of Justice. Then it examines the equivalence of these rights. It as to whether EU law organizes the rights of the accused in a similar way, whether it grants an equivalent protection. Having concluded in the affirmative, the Constitutional Council never had to explicitly invoke the identity argument before the Court of Justice. It thus allowed the Court of Justice to find common ground. These strategies, which put domestic law on the back burner in order to place themselves primarily within the framework of the Union law, make it easier for the Court of Justice to find common ground and reach a compromise. They also have an impact on the outcome of the procedure. And these outcomes are twice. First, it makes the identity argument flexible, because these courts do not put the domestic constitutional law in the foreground, and they are discussing with the court about European law, so that everybody has quite a large margin of appreciation and latitude. And this flexibility has important consequences in the field of jurisdiction. These courts, by proposing a discussion or a negotiation to the Court of Justice, but not impose on it an identity based on national law, make that the competence belongs to the Court of Justice and not to the national courts. This consequence is crucial because it respects the competence of the Court of Justice to rule on the interpretation and the validity of Union law. In this respect, it differs profoundly from strategies that rely primarily on national law. It can thus be concluded that these strategies are undeniably in line with European constitutionalism. Now, what can we say about specific national strategies? For some time now, the constitutional identity invoked by constitutional judges has included purely or principally national elements, as the German and Hungarian examples show. To what extent these national visions are compatible with constitutional pluralism and are consistent with European values. First, to the German example. In the German case law, which is already very rich, we have plenty of references to legal theory, which seem to be quite in line with constitutional pluralism, because the court is declaring that it is favorable to the dialogue of judges, judicial cooperation, it is euro-friendly, and it invokes the vast European network of constitutional and administrative rights and courts. But if we try to classify the strategies deployed by the court according to their relationship to European law and constitutionalism, we can very summarily distinguish two groups of cases. The first relating mainly to what is known in Germany as the horizontal aspect of the Solange case law, and the second vertical arising mainly from the Lisbon judgment and the conception of the democratic principle defended there. The judgment relating to the European arrest warrant fall into the first group, where the presence of constitutional pluralism is clearly detectable. The court, the Constitutional Court, contributes here to strengthening the European protection of human dignity and cooperates very closely with the European Court. In the vertical relationship, however, the rhetoric of cooperation does not hide exclusively national concerns. And here the focus is on democratic principle, which has a very specific, significant meaning in German law. It is what is the most important is the chain, the so-called chain of democratic legitimacy, where one imagines a direct link between the citizen and the government. And this democratic legitimacy allows the construction of Europe, but at the same time indicates the limits of it, limits which are the fact that European integration is possible only by and through the state. So the limits are very clearly indicated and lead to a new reading of Article 23 of the Basic Law as a receptacle of democratic principle that has become absolute and unavailable to the Constitution amending power. From these passages, I think could difficultly viewed as emanation of constitutional pluralism, but resembles much more to traditional dualism. In these passages, which are sanctioned by the judgment of May 5th, 2020, the German court accuses the Court of Justice of not using an orthodox method of proportionality control and concludes that the Court of Justice has committed ultra vires, so an excess of power. It seems to me that here pluralism is really a pretext. So I think that in this regard, the German court is quite far from pluralism. Another question is whether it has violated the European values. I think that even if Europe shares the same values, that the German court has such an exacerbated view of the values of national constitutionalism that it underestimates or ignores their European significance. And we could say could make similar comments on the Hungarian example, which, but however, with some differences which have been indicated already in precedent interventions. So I don't have to repeat it. Just to say that there also we have a discourse who seems to be in favor of constitutional pluralism, but which is completely inspired by national strategy. In any case, and however, Hungary is a special case, as so much as the Constitutional Court no longer seems to meet the condition of judicial independence, which is an essential element of the rule of law and so of European constitutionalism. So only also for this reason, I think that the Hungarian position on constitutional identity could not be deemed conform to European constitutionalism. In conclusion, I would say that plurinational strategies seem to be dubious in any case, because even if the values put forward are shared by the EU, it is nevertheless against the latter that they are brandished. this lack of loyalty and cooperative spirit is not covered by pluralism. Thank you very much.
Dear Professor, thank you very much for your inspiring presentation. And from now on, the debate is opened. Whoever wants to bring questions or to raise comment is welcome. You can also write down at the chat as well. We are open to questions, remarks. No one so far? In such a case, I will speak myself. Okay.
Pablo, I see.
Yes.
I see hand
Oh,
of
sorry.
Carol.
Oh, sorry. Helle, yes, please go ahead. The floor is yours.
Is it my time? Okay.
I think I was asked to start. Yes,
okay.
thank you. Thank you so much. And first of all, also thank you so much to the 4 speakers for these 4 very, very interesting papers. I was very, very pleased that Constance Group brought pluralism on the table, because while I was listening to Martin Bellau's presentation, I was all the time thinking about European pluralism and how the way you sort of systemized, Martin, these 3 different paradigms, I believe you called them, with the paradigms we normally speak about when we talk about European integration. So, well, thank you to both of you, but also thank you to Professor Group for bringing that to the table. But what I want to ask, and maybe it's a question for Constance, I'm not sure, is that normally we always focus, which is of course very natural, on what is viewed, at least from the point of view of the EU, as a very sort of a negative development when we look at the rule of law crisis, or we could also, I guess, call it the populist crisis in Europe, in the EU. But Constance Group, could it be interesting in a way to ask whether the populist crisis has actually also strengthened the EU constitutional identity? And the reason I'm asking this is because all our fundamental values in Article 2 in the Treaty of the European Union have been interpreted in details. They've really been crystallized. I mean, the rule of law principle has been crystallized into all these little sub-principles. So in a way, we've really moved forward, I guess one could say, in the EU in defining an EU constitutional identity. At least that's an argument I would like to try off on you, Professor Group. Thank you so much.
I think we better take the answer and then we follow with the. I think it's Professor Gray. You are
okay. Yes. You want me to answer? Okay. I would answer very briefly by saying legally yes, politically no. Legally yes, because indeed we have a much more detailed description of the union law, but politically no, not at all. You see the result of Article 7 and you see the behavior of the union, for instance, in the Balkans. That is awful. Personally, I found it awful. That's it.
Thank you very much. There was another. Yes, please go ahead, Professor Poplowski.
Thank you. I would like to set an open question for each of the tremendous authors. I would like to ask about potential differentiation between the concept of the constitutional identity and constitutional traditions, considering Polish example, because sometimes we were mentioning in Polish literature, better than constitutional identity, we were mentioning the constitutional traditions, but it was very problematic notion in concerning our example, because in fact, in Poland, each constitution was passed a bit contrary to each other, which is in fact supporting 100% what Professor Rosenfeld said about the identity as a result of the negation of what was. And on that basis, regardless from the European Union perspective, because I know that we have the common traditions of the European states, but I mean that from the particular level, nation level, is there a difference? Is there, and because from my perspective, I used to think that tradition is kind of a notion which petrifies some issues in which constitutional identity is rather, as it was mentioned, an effect of the dialogue, and in fact it is a living notion. Partially, of course, because it has to present the essence of the concept, but still it is not as petrifying as the constitutional tradition. But I'd like to know your opinion on that matter. Thank you.
Please.
The question is
oh, I'm sorry, go ahead.
I think, please, could you tell me whom are you heading your question, please? It's for everyone?
Yes, I stated an open question. In fact,
okay, open. Yes, you said that. Thank you.
I have a comment, but I'm happy to be standing in line. Pablo, is that Professor Greve?
You go ahead, please. You go ahead, please.
Okay, let me take this question and give you a general answer by referring to an American example. When you speak of tradition, the question is, at what level of abstraction do we speak about tradition? And I will mention a recent case in the United States in 2015, where out of the same right of privacy that I mentioned in my talk, a majority of the Supreme Court said there is a tradition that leads to recognizing same-sex marriage as a fundamental privacy right. And of course, it goes without saying that in the strict sense of tradition, if you're looking at concrete historical research, I am sure that you're not going to find that in 18th century America, you have a tradition of recognizing same-sex marriage. On the other hand, the majority opinion by Justice Kennedy focuses on the core of the tradition, which he understands to be two people choosing one another for a very special relationship that excludes the rest of the world and includes one another. That is a basic to human thriving, to human experience, et cetera, et cetera. So he links that, yes, in the 18th century, we thought it was a heterosexual marriage with 8 children. In the 21st century, it includes that too, but it also includes 2 men or 2 women who have the same kind of commitment to one another than our 18th century couple did. So that's why I think the question of tradition is a very malleable concept. It depends how you take it, and you can swear that it's not in the tradition of 18th century America, it has nothing to do with it, as some judges did, or you can say we see a link, but the understanding has evolved.
May I also say a few words?
If I might.
Please, you are, okay, just please, Professor Bello first, and then Professor Jacobson, please.
No, I believe Professor Jacobson was before me, and then I will.
Go ahead.
No, first I want to ask if anyone can hear me. I was told on the chat that my comments did not get through, at least many of them. So I'm sorry for that if the problem is at my end. But if you can hear me now, let me just say something about tradition. Actually, most of my work, well, very little of my work is about Europe, and most of my constitutional identity labors on the US, India, and Israel. So let me say something about tradition in the context of these various constitutions, which can be distinguished in the following way that's quite relevant to the identity. For the most part,
I think we are.
That is, they are. I'm sorry.
I think we're having some problems again. Try, please.
Oh, okay.
So maybe you can switch off your video, then
that's wise. Yes.
All right. Is that better?
Yes.
Okay. If you don't have to look at me, that's probably even better. So Constitutions can be distinguished in accordance with this question of tradition. So the US Constitution, for example, at least prior to the post-Civil War amendments, is largely an acquiescent constitution. That is to say, one that accepts what already is there as part of the tradition and is generally supportive of that which exists. Other constitutions are much more militant and are designed to be transformative. I would think of the Indian Constitution, at least in the minds of most of its framers, perhaps the South African Constitution, as being of that sort, so that the identity of those constitutions really consists of the aspiration to overcome those traditions that have largely prevailed in the society. Those constitutions that are militant may in fact be viewed as subversive. So again, the distinction between national identity and constitutional identity is very clear cut in the context of such militant constitutions in which the document is intended, in effect, to transform those traditions and produce something very, very different. If I might say something that connects to something earlier that I was saying, but which might not have gone through in terms of this static versus dynamic view of identity. Perhaps you have heard, I think probably everyone here has, of this new development, which is not actually that new anymore, in Israel, which has adopted a new basic law on the nation state of the Jewish people. That law is being contested in court, particularly by Palestinian civil rights groups. And one of the points that is being made in the petition to the court is that what the base law has done in its new text is to establish a new constitutional identity for Israel. That is wrong. That is wrong in terms of this dialogical or dynamic understanding of identity that I was trying to put forward earlier. That is to say, it assumes the very ground in dispute by asserting that the text has changed that identity. That precludes, if you accept that view, that precludes the kind of contestation that should occur between this new language and the language that appears in previous basic laws, such as the Basic Law on Human Dignity, in which case there is a struggle for constitutional identity that is going on in Israel. And I would suggest that struggle for constitutional identity, in which constitutional identity is always in flux, is what's also occurring in the context of some of the challenges in the European countries that have been registered in the various opinions in the national courts. I think I'll stop there and turn on my video and shut up.
Thank you very much. Professor Bello, please.
Yes, I just want to add something on the issue of constitutional tradition. I would like to say that it's a rather fuzzy and tricky concept for many reasons. First of all, tradition can be also invented tradition, and frequently it is. And what is more, we can the invented tradition can be derived from different points of history, which is again a result of constitutional engineering. This is something which we witness in Europe, in the West, but also in some Muslim countries where the so-called traditional Islam is actually a form of invented tradition and is used as a power source for promoting extremism. On the other hand, constitutional tradition stands in line with all these interrelated, but also to an extent antipodic concepts, starting from some legal concepts such as constitutional core, unamendable entrenched clauses, and so on and so forth, and going through more social legal concepts such as constitutional identity, constitutional heritage, and so on and so forth. So what I mean here is that, of course, tradition do matter a lot, and it can be also a background source for filling it in constitutional identity with content, but it also can be not only invented tradition, but also it can denominate path dependency. And it's not necessarily, I mean, this all debate about originalism versus futuristic approach to constitution, or what maybe Professor Jacobson calls dynamic approach. Constitutional identity is not necessarily entrenched in tradition. It might be the identity of the current generation and the future generations as well. So it's not necessarily always stuck in tradition. That's what I wanted to say.
Thank you. Can you hear me? Okay. Thank you very much. I think Professor Celine Essen, she wants to make a question.
Okay, thank you very much. It takes some time to open the camera and the micro, and this is why, I couldn't get in right away. So my question is actually, does the concept of constitutional identity have any place, or if there is, what kind of place or role in the extremely divided nations or extremely divided societies? This question, actually, Professor Greve reminded me this question because she referred the Balkans, and I know she has some considerable experience about the constitutionalism in Balkans. And my question, this is why goes to the Professor Greve, but of course, if the other speakers want to participate or, share their comments with us, I'm going to be very glad. Thank you.
Thank you, Selim, very much. Professor Greve?
Yes. I think this is a quite delicate question, and I think that most of these divided societies have no determined constitutional identity. Sometimes they try to have it. My personal experience is in Bosnia, where I have been a constitutional judge, and there you have 3 different ethnic groups, and theoretically you can have a constitutional identity in the constitution, but the Dayton agreements, I think you will agree, don't find the agreement of people at all. So it's very difficult and, in my sense, impossible to speak about constitutional identity.
Thank you very much. I think that I have here a couple of questions at the chat, but anybody else? No other? Professor Jacobson, please.
Okay, I've turned my video off. I hope you can hear me. The question about divided societies is an interesting one, but it actually underscores a point that I was trying to make in my original presentation, which is to say that the phenomenon of divided society is really emblematic of what constitutions are in general. That is to say, the disharmonic constitution is in fact the reality that we all confront, and the effort to achieve some stable notion of constitutional identity is in all societies subject to contestation from within. Now, some societies are clearly divided over the most profound issues. I adverted earlier to the Israeli case in which the statement of identity that one finds in the Declaration of Independence points in two very different directions. What's so clear-cut in the Israeli case is, however, endemic to the constitutional condition. And this question of division is really at the heart and core of constitutional identity, understood in the dynamic way that I was trying to present earlier.
Thank you very much. There is another, please, I invite Professor Rosenfeld and Professor Belov, if you want to jump in and say something more, you're welcome. Otherwise, I will go to the chat.
I'll jump in very briefly.
Thank you very much.
I think that the question of division is very important, and sometimes the constitutional identity tries to manage the division. That would be, for instance, in a country in which ethnic differences are trying to be smoothed over through some kind of arrangement, maybe federalism, where if you have geographic distinctions or excluding ethnic parties. And in other places, it doesn't work. I'm reminded of a place where it's working and not working, which is Canada. When the charter, the 1982 charter was adopted, Quebec refused to sign in. There were several conferences to try to ease in Quebec into the rest of the Canadian vision, and it never quite worked. Now, the political situation in Canada is that periodically you have in Quebec a referenda or parties that say we want to secede. And I haven't heard much of this recently. There are clearly different cultures. And one of the things that have happened in Canada is that the very idea of diverse cultures, the idea of maintaining cultural, linguistic differences within Canada is a way to try to adapt to division without the breakup of the constitutional unit.
Thank you very much, Professor Rosenfeld. Anyone else? So I will go to the chat. Here is the question. It is directed to Professor Jacobson. It says that it is important to differ, or I don't know, perhaps to differentiate politics and legal in constitutional identity. Do you see the danger of political abuse through formation of constitutional identity? So first, Professor Jacobson, please.
Well, the answer to that, I think, is implicit in what I was saying earlier. That is to say, the appropriation of legal identity for political purposes can easily be accomplished, as we're seeing in a number of places. It's sometimes hard to differentiate the political from the legal as such, but certainly the efforts that are being undertaken to assert the values or traditions within a society as more important than the principles that, for example, exist within the charters of the EU. Here, I would distinguish two terms that are often conflated when people talk about principles and values interchangeably. I would distinguish between the two, suggesting that the former be used in the broadest sense to incorporate those aspirations that we associate with constitutionalism rightly understood, and the values of any society, which are more expressive of the political facts on the ground and traditions within the society. And in the effort to achieve some clarity about constitutional identity within any given society, what one finds really is this contest between broader universal principles of constitutionalism and the values and traditions of particular society, which are often appropriated by the political powers that be, and the result is a subversion of constitutionalism that is predicated on these more broadly understood universal principles that could be, in terms of your question, be relegated to the legal dimension rather than the political.
Thank you very much. Is there any other question? Otherwise, can I say something to push forward one question that it is still hovering on my mind, and I think it is. I will tap on Professor Velov's last intervention, and I think it is somehow connected as well with a reference that was raised by Professor Jacobson concerning the idea of Charles Taylor, the idea that we are somehow, we got the identity, acknowledging and recognizing other people's interaction. This is something that is brought and developed in the ethics of authenticity. So my question is concerning this idea of phony identities. Given the fact that the idea of identity is not just formal, it is an ontological one, even for cultural objects such as a constitution. Would you think perhaps, it goes to Michel Rosenfeld as well, that some other tools to assess constitutional identity, such as this Taylor's idea of authenticity, would be helpful perhaps to build up a normative, perhaps more sound legal constitutional discourse? Professor Jacobson first, and then if anyone would like to add something.
I think that question is more directed to Michel. I'll let him take.
Okay.
I think the question that Charles Taylor asks is a question that is relevant at all levels. Who we are, what is our moral compass, what is our place in society, what can our country do for us, and of course you could extend it to constitutional identity. The constitutional identity, the problem with it generally, first of all, it's a contested term, just like liberty, equality. What do we understand by it? What is the ideal of constitutional identity? I was very interested in Gary's distinction between values and principles, which suggests that there is in the idea of constitutional identity something that is universal and stable. In other words, there's a limit to what is a liberal constitutional identity. And that limit, we can define it in terms of principles. And then we have the value side, that you can't have a constitution work within a society unless there are some elements in it that mesh with that society's way of thinking, self-identification, aspirations, etc. So I think that what the Taylor, as I understand, comment adds to this is that there is a, if you want, a moral obligation on everyone's part to try to deal with the other and with what is common to us. And it's, again, the dynamic. We have to find out, we have to evolve, etc. Can you apply this to the constitutional identity as an ideal? Absolutely. If you do research on what is the constitutional identity of Hungary today, as viewed by Viktor Orban, it may be that it certainly doesn't fit the model that, or the ideal that Taylor is speaking about. So it raises a lot of very interesting and complex issues.
Thank you very much.
Can I
Yes.
just add a few words?
Absolutely, please.
It's a very provocative and interesting question, the question about authenticity of identity, because it brings with it several more questions, one of which is how do you measure authenticity? And the answer can differ from, it can be based on different criteria, the methodology that is used, but also whether we understand the constitutional project as a holistic one or as a fragmented one, multi-discursive one based on narratives. So the authenticity of identity can mean one thing if you follow some ontological historical model, and it can mean quite different things if you apply this multi-discursive narrative approach based on narratives, on fragmented narratives. I very much like the second approach. I'm trying to create something like a theory of imaginary constitutionalism, and there you're kind of lost. If you use deconstruction, if you step up upon the theories of Derrida, Michel Foucault, then the question of authenticity is even illegitimate, right? Because it's even undemocratic in a sense. So that's what I wanted to add.
Thank you very much. Very, very much appreciated. Is it any other question, comments, rejoinder? We are facing our last minutes of this panel. Anybody else? So in closing, final remarks, let me express on behalf of the International Association for Constitutional Law how grateful and happy we are for these presentations. We have enjoyed competed and even contradictory grasps, which have been very, of course. Somebody is talking here? Sorry. Somebody want to say something? Okay. So this is my final comment. I found absolutely enriching, and thank you very much. Hope to see you later. And this is the end of our panel.
May I say just a few words?
Yes, please. I couldn't.
From
Sorry,
local.
sorry.
Thank you so much. Thank you, all the speakers. Thank you, Professor Jakobson, Professor Rosenfeld, Professor Belov, Professor Grieve. Thank you so much, Pablo, for your contribution as a chair in the session. I think it was extremely interesting session as a brilliant within our roundtable. So very much appreciated your contributions to our roundtable.
Спасибо большое, Сергей.
Oh, Celine, thanks to God you're here.
Yeah, I'm here. So shall we start, Sergey?
Yes, surely. Up to
okay.
you.
Okay, is everybody here? First of all, let me confirm that all the speakers are here. Let's see. Tony is here. Catriona is here. And Rafael. Okay, we're all set. And this is the first panel for the junior scholars. And we, during the day, we all listened to perfect, excellent presentations. Now we're gonna give the floor to the junior scholars. But before I give the floor to our speakers, first of all, I would like to express my contentment. For finally we carry out this roundtable. Sergey, if you remember, when we first considered to organize this roundtable in St. Petersburg was, I think, 2018. We were in South Korea. Can you imagine? It was about the same time as well. And after 3 years, we finally pulled it off. It not in an ideal way, because we wanted to share this your beautiful city and distinguished university, but at least we could meet together as this round table. And also I would like to thank you as well, because you really pulled off this wonderful program. You put together all the distinguished scholars who are working on this matter, the constitutional identity, which is a big thing. As a constitutional law professor, I'm really thankful that this is a really, really good and satisfying program. And as the co-chair of the Roundtable Committee, also I would like to thank you for your collaboration. You really, sincerely showed and did all the efforts to solve the organizational issues and all kind of problems. I really appreciate your collaboration with us. We could pull this off smoothly. Thank you very much, indeed.
Thank you so much. Thank you for your Thank you.
I don't want to speak more because I know everybody is very tired now. And today, originally, we were going to have 4 speakers. And all of the presentations are coming from Europe. So during the day, from the different scholars, from the different speakers, we actually heard about the constitutional identity in Europe. But now we're going to listen what the young scholars are thinking about the constitutional identity in Europe. And I said the original set was consisted of 4 speakers, but one of them, Tony Meckham, can't make it today. He's not going to be with us due to his family matters. So we're going to have 3 distinguished young scholars. 2 of them are going to talk about the same or the similar subject matter topic, which is the German constitutional identity and its relation with the international law and EU law. And one of them is Rafael Oitman. Rafael, are you here? I can see you.
I'm here.
Okay. Rafael is the, if I'm mistaken, please go ahead and, correct me. Rafael is the PhD candidate at the University of Goethe University in Frankfurt. Also, he is the assistant researcher at the Max Planck Institute in Heidelberg, which is a wonderful city and wonderful institute. And also he is the scientific advisor to the executive director of the Peace Research Institute in Frankfurt. As you see, he is a very busy person, and he will talk about the German constitutional identity to us. The floor is yours, Rafael.
Right. So thank you so very much. Thank you for having me, and also for still considering me to be a young scholar, which I'm not sure I really am. I will keep this somewhat
young. Being young is kind of relatively. You see the rest of the audience, definitely you're young.
Well, it's much appreciated anyway. So I will keep it somewhat brief, and actually just actually want to share some reflections on what I labeled the two sides of the German Grundgesetz, so the basic law, the German constitution, and the somewhat sometimes delicate balancing between constitutional identity on one side and international orientation or international outlook, if you want, on the other side. So the German constitution, as I said, the Grundgesetz, the basic law, has regularly been heralded, I would say, for its quite distinct openness towards international law and European law in particular. So European law, international law approaches in particular. So just, as one example, Articles 25 to 59, respectively, of the basic law, they enshrine a fundamental sympathy for customary international law on one side, as well as for general principles and pertinent rules of statutory international law, that is, international treaties and conventions on the other side. Beyond that, Article 23, para 1 of the basic law, quite focusedly expounds upon the modalities by and through which the Federal Republic of Germany may contribute towards, for example, the realization of an ever more integrated and unified Europe. For example, by establishing, however, minimum standards according to which sovereign rights might be transferred towards the supranational level of the European Union. So there are already, certain qualifications in place. And oftentimes this has actually been done in reference to notions such as democracy, the rule of law, and further principles that pertain to the state's very structure. So its federal orientation or its social welfare orientation. So to start with, these could be considered to resemble certain minimum standards according to which sovereign rights might be transferred to supranational or possibly in certain constellations, international entities or international structures, I would rather say. So in doing that, however, they touch upon what could be considered to reflect actually the country's constitutional identity, if there is such a thing at all. And this is actually what becomes interesting already. So it's not actually written down anywhere in the Constitution, in the basic law. So it's nowhere, labeled that there is such a thing as the constitutional identity of the country. And now the quest actually starts. So what are we talking about? And as one possible approximation, you can resort, as quite oftenly actually, to the German Federal Constitutional Court, which, for example, in its 2011 ruling on the Euro Rescue Package, expounded, and I quote, that in the revised version of Article 23 of the Basic Law, the Constitution amending legislature made it clear that the mandate to develop the European Union is subject to permanent compliance with particular constitutional structural requirements. This refers to Article 23, para 1, sentence 1 of the Basic Law. And then continuing, that in this connection, an absolute limit is created by Article 79, para 3 of the Basic Law to protect the identity of the Constitution. So here, the Federal Constitutional Court actually, comes around the corner, referring or proposing, something such as constitutional identity. So for me, the starting point for these somewhat tentative and somewhat immature considerations actually then was to say, so on one side, the constitution, the German basic law, is somewhat characterized by quite deliberate openness towards international and European law. And at the same time, what it also does, apparently, is that it shelters and it upholds a certain, what I would call constitutional nucleus. So the very core of the basic law's essence, if you wish. And this, I think, then could validly be perceived as the basic law's genuine constitutional identity. So, however, as I said before, it's somewhat hard to pin down what constitutional identity refers to, because it's not codified in the basic law itself. So while both the basic law as well as the jurisprudence of the Federal Constitutional Court therefore provide, some form or a certain kind of reference, this in concreto does not preclude, the contingency of conflicting, of contradicting perspectives, interpretations, with a view not only towards the constitutionality of specific laws, but also in terms of what is legally possible for, to do for the state, what is possible on one side being in compliance with your international orientation, on the other side being in compliance with what we could consider to be the constitutional identity. In other words, the question would actually be, and I'm not going to answer them, unfortunately, but the question would be, which degree of the basic law's international orientation is reconcilable with its institutional identity? So how do we actually balance these possibly contradicting and conflicting orientations? So this notion entails considerations then as to how diverging or conflicting interpretations of relevant constitutional principles might be weighted and balanced against one another, thereby maintaining the basic law's international adaptivity, as I would say, on one side, while also preserving the already mentioned constitutional nucleus. And beyond that, it's also interesting to look at the ramifications that could stem from an eventual pendulum rash, going back and forth between either side of this sometimes delicate balancing, and also questions such as, how could this impact the overall organizational structure, the institutional resilience, the legal standing as such, for example, of the Federal Constitutional Court being the main protagonist in actually doing the concrete act of balancing between those two possibly conflicting dimensions. So as I said, these considerations are rather preliminary. I will not be able to come up with conclusive answers. It's rather meant to, well, to spark, on one side, some interest in this way of thinking. So what can be a constitutional identity in the absence of any, written definition, and how does this actually play out in everyday lawmaking and everyday politics also? So to start with, then at the outset, the question is, what is special about the concept, or what is special about the concept of constitutional identity in the German context? As I mentioned before, is that it is not mentioned at all within the basic law itself, but that it resembles a notion that actually has constantly been developed by both legal scholarship and constitutional jurisprudence. So therefore, constitutional identity within the legal framework and structure of the basic law hence refers, to the, of course, the very own identity of the Constitution, denoting a legal concept, the precise contours of which are unclear and controversial. So we actually don't really know what we are talking about referring to constitutional identity in the context of the basic law. From a reductionist perspective, we actually could say that institutional identity then probably refers to a set of demarcations, of limitations, of certain explicit barriers or frontiers that delineate the basic law's foundational substance. So that this actually gives a certain demarcation lines. This determination actually is what could be read from some of the leading decisions issued by the Federal Constitutional Court itself, in particular from the Lisbon judgment and subsequent jurisprudence as well. Then the primary function of a contemporary conceptualization of constitutional identity could be seen in as I said before, in defining limits for the legitimate transfer of sovereign rights both towards the European Union as well as other international fora or entities, and also as a way of clarifying upon the eventual primacy of application of EU law vis-a-vis domestic law, including certain constitutional provisions. So with a view towards Article 23, para 1, sentence 3 of the Basic Law, the Federal Constitutional Court therefore distinguished the reference to Article 79, para 3 of the Basic Law actually as the factual guarantor of a constitutional identity in the German context, and also with regard to the domestic applicability of European Union laws. So in that reading, constitutional identity would primarily serve as I said before, a delimiting factor vis-a-vis contingent actions of the constitution amending legislator, and by extension, a further constitution, future constitution giving entity. Further, in the reasoning of the Federal Constitutional Court, this is then seen to arise from the mere fact that the inherent powers that are enshrined in the Basic Law, including the legislator's power to amend the Constitution, that these powers must not exceed the integrative and a stabilizing nucleus. Again, coming back to this idea of a constitutional nucleus, that is then the constitutional identity itself, really. A reconsideration or reconfiguration of this very core would then abstractly only be possible and would only be available to the constitutional authority itself, whereby this would then be viewed, or is generally viewed, as a legally competent extra-constitutional authority to exercise these competencies. Normatively, then, the relevant anchor or point of reference still remains Article 79, para 3 of the Basic Law, although it still remains somewhat blurry, somewhat unclear whether constitutional identity does indeed resemble an independent legal category, or is simply another characterization of what is already being done in Article 79, para 3, namely the enshrinement of fundamental legal values that are supposed to be maintained and safeguarded. So therefore, the notion of constitutional identity in the particular German context also has a more general objective, and that the Constitutional Court has, by emphasizing the constitutional identity in the just mentioned way, thereby has designated certain parts of the Basic Law somewhat unavailable to the otherwise stipulated constitutive powers that are included in the Constitution. For example, the legislator's power to amend constitutional provisions. So constitutional jurisprudence has therefore, or thereby, aimed both at the rather abstract level and, again, with reference to Article 79, para 3, to certain core elements or characteristics of the Basic Law in the sense of tangible limitations towards lawmaking, including for classical and formal constitutional changes and amendments and certain other variations. So in this way, the notion of constitutional identity does differ fundamentally from comparable concepts in other countries, as for example in the United States. So here we would look at constitutional identity rather in the sense of, the identity of a distinct community, of a distinct nation. As such, this kind of identity would be geared then towards the Constitution. In the case of Germany, however, it seems more reasonable, I would say, to concede that the very notion of a constitutional identity, at least in relation to classical or formal constitutional amending procedures, is actually more related to the notion of a basic structure doctrine. So again, the idea to say that, if you want to put it very simply, what is being done by enshrining a constitutional identity is to safeguard a certain basic structure, to safeguard certain basic principles that cannot be violated and that cannot be, from which we cannot depart. So in the end of the day, the question would then be, this sounds rather simple, and I'm not sure whether I really catch the point with that. But then the question would be, what does that mean for the mentioned international orientation and openness of the Basic Law that I mentioned in the beginning? So as most good lawyers will actually say, it pretty much depends. So there is no clear answer to that. Even though we have this overall outward looking and rather, let's say, internationally sympathetic orientation of the basic law, this is not per se compromised by the very fact that we want to maintain, or that we actually accept that there is a certain constitutional nucleus that has to prevail, that has to be maintained, no matter how noble the cause might be that could otherwise justify, the assumption of international legal obligation or the delegation of additional powers towards the supranational level, for example. So it's rather this notion of constitutional identity as a safeguard, as a safety net, as the last bastion, so to speak, against a doing too much approach. So notwithstanding what your noble aspiration might be. And so therefore what it does, what the principle of constitutional identity does, is it provides protection of fundamental constitutional values. So if there is such a thing as constitutional identity that is inherent in the basic law, even if it's not deliberately mentioned, I would argue that it is inscribed basically and simply in the eternity clause of Article 79.3 of the basic law, in that facilitating what could be perceived as the very constitutional identity of the German basic law. And with these rather preliminary remarks, I would like to close.
Okay, thank you very much for your intervention. Then let's continue with the same subject matter if you want to. Our next speaker is Tony Finkenshare. He is also the PhD candidate at the University of Regensburg. Tony, are you here? There? Okay, great. I can't see you now, but I'm pretty sure I'll see you soon.
Fine.
Okay, the floor is yours, Tony.
Thank you very much.
Okay, so here we go. Okay.
First of all, I want to thank the organization team, especially the Dean, Professor Belov, and Professor Anna Gritsenko, for organizing, making this happening. I know it is a lot of work to do things like that, so I really appreciate your support and your effort. Celine, I want to thank you too for being the moderator of this panel, and let me just say it's always inspiring to meet people like you, and because I see here other familiar faces like Constance Greve and Marcelo Figueiredo, to meet person like you who have this international open-mindedness. It's an inspiration for a young scholar to meet persons who are open to this kind of thing. So thank you very much. It's come from the heart. You know us quite well, and I hope next time we see in person. Yeah, I will talk about the same topic, but I think it could be a bit different. So we have some points for discussion, but I would say I'm not too far away from the things that my colleagues has already said. But in some other points, I think I have a different point of view, and I think this could be interesting for a discussion. So, the Constitution represents the basic legal order of a state. This basic national concept is relativized by external law, international law, and especially supranational law, as a result of globalization and Europeanization. The principle of open statehood is thus immanent in the Constitution. The limit of this external relativization is regularly described with the concept of constitutional identity, I would say, our today's topic, which in Germany has again received prominent support from the German Constitutional Court in its Lisbon decision. So, in the German jurisprudence, when we talk about constitutional identity, then the rulings are regularly referred to the process of the Germany's integration into the European Union. In this context, I would say the concept of constitutional identity is discussed very strongly. The aim of this lecture or of my presentation is therefore to analyze whether this jurisprudence is convincing or whether the identity of the German basic law should be not defined or should be defined in a different way. The importance of such an analysis can be illustrated by the following questions, which, however, will not be the subject of this presentation. But to make it clear, I think it is nice to point them out. How can the principle of primacy of application of European law over national law can be compatible if there's a nationally conceived constitutional identity, as the German constitutional states? That conflicts with the supranationalization of the German basic law. And secondly, who makes the decision as to whether the possible constitutional identity of a member state has been violated? The European Court of Justice or the German Constitutional Court, the National Constitutional Court? In determining the constitutional identity of the German basic law, as I have said before, and as my colleague has already said too, the German Constitutional Court regularly refers to Article 79, paragraph 3 of the basic law, since the norm declares certain principles such as human dignity, Article 1, paragraph 1 of the basic law, the federal structure of the federation, or for example, the principle of the rule of law or democracy to be unchangeable. Thus, if certain principles and values are declared inviolable, the identity of the constitution must lie in them. So this states the German Constitutional Court. In this respect, Article 79, paragraph 3 of the basic law is also called the guarantee of eternity. However, according to the court, this has also the consequence that, particularly in the case of participation in the European Union through the transfer of sovereign rights that my colleague has already explained more widely, I will keep it shortly here, the core of the Constitution must be preserved in accordance with Article 79, paragraph 3, which already resides from the integration norm of Article 23, paragraph 1, sentence 3 basic law. That refers to this so-called eternity clause. Thus, in the above-mentioned Lisbon ruling, the Federal Constitutional Court emphasizes that Germany's integration into the European Union would not lead to a renunciation of its own national identity, but rather this would be the limit of such participation. In this context, the court also refers to Article 4, paragraph 1 of the Treaty of the European Union, according to which the member states would be granted, and here is again the word, a national identity. It is written like this explicitly in the text. As a result, the German Constitutional Court sees it as its task to declare European Union law acts inapplicable in the event of a violation of Article 79, paragraph 3 of the Basic Law, contrary to the primacy of the application of European law, or as recently, to be allowed to reject the rulings of the European Court of Justice. In summary of this first part, my presentation, it should be noted that according to the German Constitutional Court, the identity of the German Basic Law would result from a national conceived understanding of the Constitution, and that the legal core of the basic order of the German state could therefore not be relativized by external law. So I think this was meant with the word rigid nucleus, or the last bastions. I don't know. Such a formal nationalist definition, from my point of view, of the concept of identity is not only unconvincing. In my opinion, it is wrong. Because of the incorporation of international law and the integration of the member state, like Germany, into the European Union, the definition of identity can only be made from an international or supranational perspective. First of all, the opinion that the wording of Article 79 of the Basic Law must be interpreted narrowly, and thus only the values and principles mentioned there are decisive for the definition of constitutional identity must be clearly rejected. Rather, such an understanding itself contradicts the basic ideas of the constitutional legislator. It is therefore itself contrary to the concept of the identity of the constitution. Why? Firstly, a constitution is not final and fixed by its very nature, but develops along with it, whereby the identity grows and changes in the same way. The constitution is a living instrument. It adapts to the circumstances of today's world and people's way of life. Its organizational dimension is therefore intended to keep the community functioning. In addition, it has an ideal character, as it can be seen above all in its reference to the human being. However, it would be contrary to these anthropocentric basic ideas if a part of the Constitution, like Article 79, paragraph 3, were formally rigidly defined from the beginning by a narrow interpretation of the wording. Let me just clarify. This does not mean that principles such as democracy or the rule of law are open to debate or are open to be abolished. No, on the contrary. Rather, it should be emphasized at this point, that due to the actual internationalization of our world, the common values that people share, secured, for example, by international and European Union law, can no longer be determined from a national perspective. In other words, it would be against the reality of human life and thus also against the Constitution as a living instrument if certain parts of the basic law were not understood dynamically, in a dynamic manner. In other words, the factual development in society, politics, and legislation must likewise not be excluded in the interpretation of Article 79, paragraph 3, basic law. Secondly, a constitutional legislator always has in mind that the Constitution is designed for continuity. It is intended for an uncertain period of time. The norms are thereby also intended to aim for acceptance. Otherwise, the Constitution would not be suitable as a permanent instrument. So, the Constitution wants to express in a continuous form how society is constituted. However, if certain parts of the Constitution are not given the opportunity for further development, there will be a risk that there will be an increasingly lack of acceptance. And as a consequence, that the Constitution will be abolished. To put it simply, what was the identity in 1949 cannot be or cannot mean the identity in 2021. For example, in 1949, it was not clear yet that the Charter of the European Human Rights would play a role in the interpretation of the German Basic Law. As a second brief conclusion, it should be noted here, the interpretation of the clause of Article 79, paragraph 3, in which the German Constitutional Court sees the identity of the German Constitution, cannot be made from the perspective of the year of 1949. A narrow interpretation of the wording must be rejected. Rather, even when defining the values and principles that were mentioned there, or that are mentioned there, one must always take into account that the Constitution is developing, which specifically means that it stands in an international and supranational context. In other words, the identity of the German Basic Law must not be separated from the fact that the German Constitution is shaped by the idea of open statehood as an essential element. So what does this mean in concrete terms? For example, Article 2 of the Treaty of the European Union states that the values on which the European Union is founded are respect for human dignity, for instance, freedom, democracy, equality, the rule of law, and respect for human rights. By joining the European Union, the member states have recognized these as common fundamental pillars. In this respect, however, it is within the competence of the European Union to determine the objective functional core of these common values of Article 2 of the Treaty of the European Union. Because their universal significance would be lost if each individual member state were to determine their meaning independently. With regard to the concept of identity of the basic law, this means in turn that the core elements of the Constitution, due to Germany's participation in the European Union, may only be seen in the light of Union law, such as, above all, the objective fundamental principles of Article 2 of the Treaty of the European Union. So, the member state can only determine the implementation of these fundamental rights, according to which it can only give itself a national identity. In this sense, Article 4, paragraph 2 of the Treaty of the European Union must be interpreted. In concrete terms, the core content of democracy, for example, is determined at the union level. The member state, on the other hand, decides how it guarantees this, for example, through representative forms. Germany's integration into the European Union thus universalizes the values of the Constitution. This statement can now also be underlined by the recent case law of the Federal Constitutional Court, the German Federal Constitutional Court itself, according to which the German Basic Law, like for example Article 1 of the Basic Law, that is, I would say with no doubt, part of the identity of the German Basic Law, must be interpreted not only in the light of the Charter of the European Human Rights, but now also in terms of the fundamental rights of the Charter of the European Union. So, to sum up, the German Constitutional Court can identify the identity of the German Basic Law, but a national conceived definition is not sustainable. So I would say a national rigid nucleus is not sustainable, because due to the integration of the Basic Law into a supra and international human rights order, the Constitution can also only be understood in the light of these guarantees. In other words, if the Constitution is to be understood or has to be seen as a living instrument, then its identity must also be as living. This decisive point is therefore the following. The identity of the Constitution is anthropocentric. Its orientation towards certain fundamental rights that serve, or fundamental values that serve human beings, cannot be made from a national perspective. It must be always made in a supranational, international perspective. Thank you very much.
Thank you very much, Tony. So your comments are pretty sharp and pretty clear. Thank you very much for that. And I'm pretty sure we're gonna find a lot of points to discuss with you. Okay, our third and the last presenter is Catriona Shirley Molay. Catriona is the candidate, PhD candidate as well, at the European University Institute in Italy. And she is, in her thesis, she is studying on Scottish constitutional identity. Now, let's see, because UK and the Scottish case is totally different, because when we talk about the constitutional identity, when we give examples, we always give examples from the rigid and written constitutions. And now we're going to see another or different example from Catriona. Catriona, the floor is yours.
Thank you very much. And I'd also like to start today by saying thank you very much to everyone involved in organising this roundtable. I am absolutely delighted to be involved, and I found the discussion so far to be fascinating, and I'm really looking forward to that continuing in the coming days. I have some slides for my presentation, so I'm just going to try and share my screen. There we go. I hope this has worked. So my presentation today is about Scotland, Scottish constitutional identity, and I study that through something called the Continuity Bill affair, or the Continuity Bill reference. The Continuity Bill affair was essentially a power struggle in the post-Brexit British Constitution between the British and the Scottish governments. And although the legal issue itself at the heart of this was really quite technical, I think this technicality masks the fact that this whole dispute was actually about identity. Why was there a power struggle in the first place? It was all about Brexit. As I'm sure you are aware, the Brexit referendum result was not even across the United Kingdom. And in Scotland's case, Brexit was rejected. However, the British government chose to push ahead with Brexit, and that could be done because England endorsed Brexit, and England is by far the dominant country within the United Kingdom. However, in my view, this whole dispute is more than just a political one. And you can see that in how both sides, the Scottish and the British, are approaching the debate, because they're sort of shadow boxing. They're both coming at this dispute from what appears to me to be in quite different constitutional frameworks. And my argument essentially is that this is the result of a separate constitutional identity being constructed in Scotland. So this is just very quickly the content of what I'll talk about today. I will start with some very basic points about the British Constitution. I'll then introduce the Continuity Bill, and I will describe that, tell you what it was all about, before very quickly talking about my methods and my questions, and then I'll give some observations finally. So the British Constitution, as I'm sure you're all aware and has been mentioned, there is no codified British Constitution. There is no written text. And in the absence of this constitutional text, the principle of parliamentary sovereignty has traditionally stood in for the British Constitution. Parliamentary sovereignty is essentially the idea that the British Parliament in London has virtually untrammeled legislative power. So the only limit upon the power of the British government, the British Parliament, sorry, is that it cannot bind its successors, i.e. it could not pass some kind of fundamental unamendable change, because that would destroy the concept of parliamentary sovereignty itself. So there can be no unamendable core within the British Constitution. And that basic parliamentary sovereignty idea is a little bit paradoxical when one thinks about some other aspects of the British state, because the British state is also multinational. It's a union state, very much in the sense that it was formed by unions between countries as opposed to conquest of countries. And this is most important in Scotland because the UK first came into being with the 1707 union between Scotland and England. And you can actually see this slight paradox right back at the start of that union, the debate that was had over that union in 1706, because the Scottish side seemed to absolutely believe that this was a contractual union between two equal nation states coming together to form a new nation state, the United Kingdom. Whereas on the English side, the perception seems to be one of incorporation. Scotland was going to be absorbed into the English system. And this background tension was replicated in the union itself. because although parliamentary sovereignty was kept and the Old English Parliament became the British Parliament with a few Scottish MPs, Scotland's nationality was preserved. So Scotland was left as a separate jurisdiction, and it was left with several institutions. And so that just sits a little bit uncomfortably with the whole constitutional system, which is premised on the idea that Parliament is completely unrestricted in its powers. The theoretical, hypothetical question that's often raised is, could the British Parliament abolish Scotland? And from the English point of view, yeah, absolutely. From the Scottish point of view, that would be a breach of the Acts of Union, which were the foundation of this new state. And you can actually see this general tension continuing up until the present day into contemporary constitutional events. So this kind of, the attempt to solve this tension between multinationalism and the powerful British Parliament was something called devolution. So powerful parliaments were created in the smaller nations of the UK, and in Scotland's case, that was done through the Scotland Act, which created the Scottish Parliament and government in Edinburgh. These parliaments have hugely wide-ranging powers. However, their authority and their competences are derived from UK statutes. So again, it's the supreme British Parliament who will, Britain, if it wanted, theoretically could abolish these institutions whenever it wanted. However, this is a little bit more complicated when you consider that the Scotland Act was only passed after a referendum of the Scottish people. And this brings in a complicating factor with parliamentary sovereignty, which is simply how connected is it to reality? I mean, theoretically, the British Parliament can do whatever it wants, but actually can it in terms of real world application? And this complexity can be seen in how devolution works itself, because although Westminster can theoretically just entirely ignore, overrule the Scottish Parliament, in practice, there was a huge set of political conventions built up that essentially prevented this. The most prominent of these was a convention which stipulated that the British Parliament had to ask permission from the Scottish Parliament if it was going to legislate on an area which affected their powers. And this was really quite successful prior to Brexit. There really was this system whereby, sure, the British Parliament probably had this power to just tear it all down, burn it all down, do whatever it wanted, but there was also the understanding that it just wouldn't do that. And this kind of slightly confused picture was called constitutional unsettlement, was the term used by Neil Walker to describe it, where you still theoretically had this grand driving notion of parliamentary sovereignty, but it didn't really apply so much in the modern British Constitution. And some people argued that, in fact, that parliamentary sovereignty had become merely a symbol of the British Constitution. And so then Brexit came along, and Brexit was a real shock to this doctrinally a bit unstable, but ultimately quite harmonious constitutional order. And the Continuity Bill, which I'm talking about today, was a result of that. So the Continuity Bill affair, just to quickly give you the facts, was about returning powers which had previously been under EU competences, which were going to come back to the UK, had to be transposed into domestic UK law. And in order to do that, a bill was passing through the British Parliament. However, the problem with the British bill was that it gave all of those returning powers to the British Parliament, when in fact, under the Scotland Act, those powers should have gone to the Scottish Parliament. And so in response to this, the Scottish Government brought forward its own bill in the Scottish Parliament, which essentially covered the same territory, but gave those powers back to Scotland. That Scottish bill was passed very quickly with a large majority, but it was immediately challenged by the UK government and taken to court. In that Supreme Court case, The Supreme Court actually ruled that, yeah, most of the Scottish bill was fine. There was no exceeding competences at all. However, in the time that that court case had happened, the British government had managed in the meantime to pass its original bill, and thus parliamentary sovereignty came into play. The courts couldn't do anything. Essentially, Parliament had overridden the whole issue. So essentially, the Continuity Bill was the first time that the British Parliament has sort of used its brute force over smaller nations of the United Kingdom. It was the first time the UK had taken a Scottish Government Act to court. It was only the second time that they had pushed ahead with legislation which did not get that consent from the Scottish Parliament I talked about, those conventions. And those conventions seem to have completely broken down since Brexit. They no longer are effective. And it very much seems that the British Constitution is re-centralising back towards London, and parliamentary sovereignty is no longer perhaps symbolic. It's now absolutely the normative core of the British Constitution, and that's being upheld by the courts. So why do I insist on seeing this whole thing through the lens of constitutional identity? I think it's all connected to identity because Scottish national identity is so tied up with Scotland's constitutional position and with the idea of unionism. So unionism, as I've mentioned, actually forms a narrative with devolution in Scotland. And I mentioned the fact that devolution was only founded after a referendum campaign. And that referendum campaign was driven by a civil society group who called themselves the Scottish Constitutional Convention, which is a reference to pre-union Scottish constitutional law. And they published something called a claim of right for Scotland, again, which references something which happened in pre-union Scotland. And that claim of right started with the phrase, the people of Scotland have the right to choose the government best suited to their needs. And this is again a direct reference to pre-union Scotland, and that comes from something called the Declaration of Arbroath. It's on the slide there. The Declaration of Arbroath is a medieval document which supposedly asserts Scottish popular sovereignty. It absolutely does not. It's from the year 1320. There was no such thing as popular sovereignty, but the myth is very widely believed in Scotland. So that referendum was successful for devolution, and that led many people to argue that the Scots had now carved themselves out as a constituent power within this sort of union constitution as they saw it. I'm not sure if any of that previous section has made sense, so I'll use the words of Neil McCormack, who put all this much better than I ever could. And he essentially said that Scots have a cultural imagining of sovereignty embedded in their national identity. And just to sum up so far, I think that the point of tension leading to this identity creation is that basic unitary union divide, that parliamentary sovereignty versus the union state idea. This cultural imagining of sovereignty is a key part of that. But what does it mean constitutionally? How can this constitution-infused national identity become a constitutional identity? And in order to assess this, because what I'm interested in is the fact that these cultural aspects of Scottish sovereignty are being used in the Brexit debates, they're being used in the courts, they're coming through very prominently. I want to explore what it's being used to mean normatively, and what the speakers understand this constitutional framework to be. In order to do this, I've taken a socio-legal approach, and I've read through the transcripts of the parliamentary debates around the Continuity Bill affair from both the UK Parliament and the Scottish Parliament. I have also read the Supreme Court case, but I'm not going to cover it today just for reasons of speed, essentially. And I've used a really loose critical discourse analysis framework to cover this, which I took from a study of Austrian national identity. And I've sorted the observations I've made from these debates into two very broad categories. And the first are just very basic strategies of identity construction. So who is in our in-group and who are the others that we're defining our identity against? And perhaps unsurprisingly, all politicians from Scotland do not use the words us, we, and our to refer to the United Kingdom. They never do that. Us, we, and our for Scottish speakers only ever refers to Scotland. And again, perhaps unsurprisingly, all English politicians, no matter their political party, no matter whether they're pro or anti-Brexit, use us, we, and our to talk about the whole UK. They talk about our nation, our laws, our lives, our future. And so there's just a broad dichotomy there. The one exception to that broad dichotomy is Scottish pro-Brexit politicians, because they have to work a little bit harder to make their argument. And this brings me on to slogans, and there's one slogan I want to highlight, which is our precious union. It is a slogan which is used very, very heavily by those Scottish pro-Brexit politicians. And it's the only time a Scottish actor uses a collective word to refer to something which is pan-British. But note that it's not our precious country, our precious nation, or anything like that. It is our precious union. Once again, it is the union that is seen as the shared characteristic across the UK. It's much thinner than perceiving there to be a broad identity across the United Kingdom. And then this leads me on to the second category, which are much more concerned with constitutional law. The first is just perceptions of the Constitution that various actors have. And once again, English MPs universally adopt this classical parliamentary sovereignty viewpoint. And so there's a quote there from an MP, which essentially shows that they viewed this whole issue of what powers go where post-Brexit as one of benevolence and generosity on their part, not actually a constitutional requirement at all. Unsurprisingly, Scottish actors actually perceive this whole continuity bill affair as a breach of the Constitution as they see it, that sort of union state that they see. And the debate on this is a little bit more interesting at the Scottish level between the pro-Brexit and the anti-Brexit Scottish politicians, because once again, the anti-Brexit Scottish actors take this really expansive view of devolution as sort of the fulfillment of Scottish nationhood, that kind of thing. But the opposing side, the pro-Brexit Scots, don't dispute that at all, nor do they dispute this sort of normative force of the idea of the Scottish people, of this cultural sovereignty. And instead, they have to talk around the debate and construe it as, because Scotland chose to remain with the United Kingdom in the 2014 independence referendum, therefore we consented to this. So they're still having to base it in the idea of authority lying in the Scottish people, which is absolutely not the case for England. It's very much one country there. And then this just very briefly brings me on to my final point, which is about the different people or peoples. And perhaps unsurprisingly again, British actors see them as being one British people headed towards these sunlit Brexity uplands. And they see that British people having singular values and identity. And this obviously is very different for Scottish speakers. So this is a long quote, you don't have to read it all, but it's from a anti-Brexit Scottish politician, and it's fairly typical for the kind of statement that they're making. So they're basing it in this cultural sovereignty in Scotland, but using it in a legal contemporary matter. And so here they're using the norm of Scottish popular sovereignty to argue against this not giving the powers to Scotland. So this cultural idea of sovereignty is becoming more powerful. It's being used as a normative argument, but it's being used all over the place to mean many different things. And so with that, I'll give my concluding remarks. On the transfer between this sort of quasi-legal native Scottish idea of sovereignty and that linkage with Scottish pre-Union history, that is absolutely not reflected in or compatible with the current British Constitution as it recentralises back towards this unitary idea of the British people. The meaning of that quasi-legal native Scottish argument is not that fixed at present, although it's being used normatively. And I think that it would really make the transition into being a hard legal principle, into being the constitutional identity core, would be with an independent Scotland. And interestingly, in the 2014 referendum, a draft constitution was produced by the Scottish government, and the opening clause of that constitution was the statement, in Scotland, the people are sovereign. And in the explanatory notes, that fairly universalist principle was actually entirely derived from these cultural, quasi-legal, mythological Scottish sources. It was the declaration of Arbroath. At present, within the UK, I think you can just observe that this gap between the British and the Scottish constitutional stories is not going anywhere. So that Scottish idea of sovereignty is going to continue to cause problems within the British Constitution as it changes post-Brexit. And with that, I will say thank you very much for listening.
Katriona, thank you very much for your presentation. I would like to ask whether there are any questions. There is a French comment. Okay. So is there any questions to the panelists? Okay, Constance, now I see you. Go ahead, please. You don't have, open your micro.
I thought it was already activated, excuse me. I have a question to Tony and a question to Catriona. I would like to ask Tony whether he's in favor of a competence of the German Constitutional Court on reviewing Article 79, paragraph 3. I want to say, are you in favor of the competence deemed by the Constitutional Court to review constitutional amendments? Because when I take seriously what you said, that the interpretation of Article 79 is wrong or not good, should we conclude that the court should not control constitutional amendments? This is my question. And I also have a little commentary because I wrote an opinion of the former president of the court after the decision, the judgment of May 5th, 2020. And President Voskuhle said, yes, we will fight together. We together is the Constitutional Court and the Court of Justice, the European. We will continue to fight together in order to know what the law will say. That is meaning there is only one solution, and indefinitely it's the German solution, of course. So this is just a little commentary. And then I have a question to Catriona. I would like to know if in the difficulties in Scotland, the Catalonian case has played a role. And was it a positive or negative role? That would be interesting because there are some analogies and but the stories are not going on at all in the same manner. So it would be interesting to have some reflections on this point. Thank you.
Thank you very much, Constance. Let's start with Tony. Go ahead, Tony.
Thank you, Constance. So my clear response is that it is within the competence of the German Federal Constitutional Court to interpret the Article 79, paragraph 3, yes, but when he does this interpretation, he has to respect the fact that the German Constitution is a living instrument, it is dynamic, and what we define, or the values of Article 79, paragraph 3, must be interpreted in a dynamic way and in a supranational way. In concrete terms, the principle of rule of law that is written in Article 79, paragraph 3, cannot differ, cannot be different as it is understood on a supranational level, as it is understood in Article 2 of the Treaty of the European Union. So I would say the core, the objective core, for instance, to make it concrete, of rule of law needs to be understood or needs to be defined at the level of the European Union. And how it is understood in the supranational context, then the German Constitutional Court has the right to interpret in this light Article 79, paragraph 3, and it says, or it has the right to define the identity of the German Constitution, has the right to define Article 79, paragraph 3, but to sum up, always in the light, or always with regard to the fact that the German Constitution, Germany, is integrated into supranational and international systems, and that the German Constitution, and therefore also Article 79, cannot be understood in a rigid, unchangeable manner. It must be seen in a dynamic manner that adapts to the circumstances of today's people's life, and not to the interpretation that was thought in 1949. That's my answer.
Thank you very much. Catriona?
Thanks. That's a really interesting question. And the role of Catalonia in Scotland is really interesting. Most obviously, in a very practical sense, Scotland's sort of imagined constitutional independent future is absolutely contingent upon EU membership. And so there's a great deal of alarm at the idea that any possible future Scottish EU membership could be jeopardised by Spain, essentially using its veto to keep Scotland out because it doesn't want to give its own autonomy movements any ideas. And there was a lot of alarm at the scenes we saw with the Catalan independence referendum in Scotland, and it's led to this pursuit of the issue being framed very much in terms of, we want independence, but we only want it legally. You've got to be so careful in construing this that it's going to be absolutely consistent with the British Constitution. And so that is why there's no possibility of a wildcat referendum in Scotland. There's going to be no unilateral declaration of independence. Instead, the approach seems to be pushing how far we can legally. Unfortunately, that's not very far in the British constitutional system, because the British Parliament holds all the cards, but there is absolutely no prospect of any unconstitutional illegal action being taken in Scotland. I think apart from that, the frames are quite different between Catalonia and Scotland, because as I understand it, succession is expressly forbidden in the Spanish Constitution. It's not in the British Constitution. it is perfectly possible. In fact, the Acts of Union say that either party can withdraw whenever they want, but it's the constitutional means of getting to that withdrawal that the British Parliament holds all of the cards over. So yeah, that is what I would say on the Catalan dimension to this.
Thank you very much, Katerina. I see a lot of hands up, but I would like to ask you something related to Catalonia, not only Catalonia, but Spanish issue, because we talk about the Catalonia all the time, but also even before Catalonia, they had the Basque Country issue. And I would like to ask you the role of the constitutional courts regarding the, conflict or clashes between different constitutional identities. I know in Britain, the Supreme Court is not the, strong type of court in terms of the constitutional review. But how do you predict the role of the Supreme Court regarding the, resolving the issues between the sub-state constitutional identities and the state constitutional identity?
I'll just come back on that. It's a really good question. I'm afraid I can only talk about the UK because I know very little about Spain. But the role of the courts in this whole saga is an interesting one, because prior to Brexit, in that period of constitutional unsettlement, the British Supreme Court was actually very, very inclined to go against parliamentary sovereignty and say, no, we have a much more complex constitution. They leaned into some of these Scottish Unionist narratives a little bit. But of course, that trend has been completely reversed since Brexit. The reasons why the court has so flipped in its interpretation, I don't know. I speculate that it's because we don't have a tradition of a strong constitutional court in the UK, and the judges are simply uncomfortable with them taking on this role, so they're just saying parliamentary sovereignty, it all gets decided there. But I foresee the courts playing a major role in this possible Scottish independence issue, because the current strategy which is going to be used by Scotland's ruling government, who were recently re-elected on this manifesto, is to push forward a bill for an independence referendum to be held under the Scottish Parliament's powers. We don't actually know if they can do that. It might be beyond their powers, it might not. And so what's probably going to happen is that they're going to pass this legislation, is going to be immediately challenged, and the Supreme Court is going to have to make a very, very big decision over that. From their jurisprudence since Brexit, though, it does seem likely that they'll just say no British parliamentary sovereignty. But it's a big unknown, and it's going to be a big issue in the coming years.
Okay, so I see Hele's hand is raising up. Go ahead, Hele.
Thank you so much, actually, to all of you. I really enjoyed all of the papers. My question will go to Raphael and to, sorry, I was just looking, Tony, there you go. So, because I can ask the same question to the two of you. I found your presentations really intriguing. And if I understood them correctly, they, in a way, they both reflected that the German Constitutional Court maybe goes too far in protecting the nation state through its interpretation of constitutional identity. If I got it wrong, you'll just tell me. But just framing it a bit square here, that seems to be the case in both of your presentations. And now I'm going to ask a more sort of, I guess, social legal question. So excuse me for that. Why do you think that the Constitutional Court is acting this way? Why does the Constitutional Court see it as this protector, I guess, of the nation state, which is then reflected in how it interprets constitutional identity? I mean, is this about legitimacy? Are they searching for some kind of popular legitimacy, some other kind of legitimacy? Is it a generational question among the judges, the age of the judges, and the legal system they come from, they were educated in? what do you think? I mean, or is it because they are actually part of the national sort of institutional system? I know it's a difficult question. It's not a purely legal formal one, but it just really, I find that extremely fascinating. Thank you so much.
Thank you, Hille. Who would like to start first? Tony or Raphael?
I can try to start actually. That's a very good question indeed, and one where I think it's not that easy to find an answer to. I think, I mean, you definitely got it right in terms that at least I would say that the I'm not 100% sure whether the Federal Constitutional Court actually goes too far in terms of protecting what it conceives to be the constitutional identity. Personally, I would think, yeah, probably that's the case. I think what it definitely does is that it is protecting constitutional identity based on a formal reasoning, on formalistic grounds. That would be the first thing. The second point of your question, why are the judges are doing that? I could be mean and say that, well, judges are alpha animals and actually want to make sure that their role is being sustained, and the Federal Constitutional Court, I think that's fair to say, is a very self-conscious and very in that sense also a very strong, well, also political factor. And I mean, I would actually need to think about that a bit more, but like out of the blue, I would actually make the point that if you look at the the jurisprudence of the Federal Constitutional Court regarding the question of to which extent it is possible to integrate more into the supranational structure of the European Union, for example. I think this goes into this sort of like this pendulum rash I was talking about earlier. That on one side, yes, there is this general sympathy for all matters European, in terms of we want to integrate into being in the heart of Europe. We want to integrate and we want to support supranationalism, but at the same time, and I think this this can be traced in many of the judgments of the Federal Constitutional Court, that there is always like this little residual in terms of saying we give you that and we are happy to give, well, probably not happy, but we are ready and willing to give authority and sovereignty actually towards the supranational level, but we always want to make sure that in the end of the day we are also the ones that decide. And if the going gets tough, we are still in the front seat. And I think the judgment last year, and where I think just yesterday, the news broke out that the European Commission is actually suing Germany for what the Constitutional Court did, and actually ignoring the Court of Justice and its ruling. This is like this power play of a rather independent and a rather autonomous domestic, and in that sense also international actor. So I think there is a very strong perception within the Constitutional Court that we are not some form of ordinary domestic legal institution. We are the German Federal Constitutional Court, and in the end of the day, we still have a say in pretty much everything that is going on in terms of transferring sovereign rights to the supranational level.
Thank you. Tony?
So with regard to your first question, does the Federal Constitutional Court goes too far? I would say yes, and I would add that it is also, or he does it in a contradictory way. So on the one hand, he states that we have this national identity in Article 79, paragraph 3, but on the other hand, it says that, for instance, as I have already mentioned, the fundamental rights, like also Article 1, human dignity, must be interpreted in the light of the European Charter. And secondly, when you look to the recent rulings, and I think the most famous one is now the ruling on the climate change, then the Federal Constitutional Court states that our constitution has a universalistic character. So it states that people abroad from Germany also gain protection, can refer to the principles, the values of the German constitution. So to put it in another way, the German Constitutional Court recognizes in this ruling that the values of our constitution are universalistic. They cannot be seen or they cannot stop on the, or cannot only be defined on the German territory. There is no principle of territory. And for me, this is a clear contradiction. If the German Constitutional Court on the one hand says we have values, national values that are unchangeable, but on the other hand, it states that the German Constitution is open to cross borders. We have to see it in a functional way, and the values must be universalistic. And to your second question, I think Raphael has it said in a nice way. I can maybe add a little stronger. I think we have to, first of all, the German Constitutional Court has always been very self-conscious, and as Constance already said, I think it is in the tradition of the German Constitutional Court to see itself as the second real player in the European Union. But I would say we have, or the first, the only one, yes, but we have 27 member states. And so my answer is that I think it's in the tradition of the German Constitutional Court to maintain the last word. And secondly, we cannot forget that judges are persons, they have their own view, and you can check it. The rulings on for instance, the famous ruling of last May was written, I think, or mainly done by a judge that I would say it's of course correct, but I think there are personal opinions behind this judgment too, and we cannot forget that judges are people, are professors that have their own, own point of view. That's my answer.
Thanks very much, Tony. Okay, I see Jakob. His hand is up as well. Jakob, here you go.
Yeah, thank you very much. First of all, to all the panelists for your wonderful presentations. I've learned a lot. And my question goes to both colleagues deliberating on the German constitutional identity. So I want to ask you about those 5 areas that the German Constitutional Court kind of defined in the Lisbon decision: taxation, religion, culture, education, fiscal policy, and welfare or social policies, kind of as a content of the principle of democracy and thereby constitutional identity. But then this decision was so starkly criticized, rightfully so, and also this, unhappy creation of a theory of a state, which is obviously flawed. And then my feeling was that basically they kind of the German Federal Constitutional Court kind of went away from those areas, and it didn't pursue it didn't pursue by the names in their following decisions those areas again. So my question to you is, do you have the feeling that this is some kind of, that this potato was too hot and that they kind of left it out of the display what actually construes the principle of democracy in the name of democracy while protecting the constitutional identity? Or is that something that awaits for further, I don't know, developments? So, and in connection to that question, I will be very brief. What would you say if then the German legislator would adopt, for example, German constitution and specifically state, for example, okay, fiscal decisions are part of the competence of the European Union as a by the constitutional amendment. Do you think then the Bundesverfassungsgericht would still be able to claim that they're protecting principle of democracy in the name of democracy, while the democratic decision would be to, to transfer this field of policy making? And that's it. Yeah, thank you so much.
We thank you very much. It's an interesting question, actually. Okay, Rafael, what do you think about this question?
Well, if I had a crystal ball, I might have a good take on that. I really don't know, and I'm really hesitant to say. I mean, I think in the end of the day, it actually comes down to also what Tony has been saying before. I mean, I think the decision of last May is a pretty good example, because like the previous question, went to why is the court actually behaving the way it does, and why is it actually seizing this rather or probably too ambitious role for itself. Yeah, I mean, it sounds like a commonplace, but I think in the end of the day, yeah, it comes down also to the question of who is sitting on the bench. So looking into the future under these what-if constellations, so if there would be something resembling a true European fiscal order, would that be something that the court would actually rule against ultimately? I don't know. I mean, it's just as, I mean, this actually, takes us far down into the rabbit hole, right? Like the question of, who's actually becoming a judge at the Federal Constitutional Court? What are the mechanisms by and through which you become a judge at the Federal Constitutional Court? And to what extent is that actually resembling political preferences, that actually are then responsible or decisive for, passing these laws in the first place? Looking at the history of the jurisprudence of the court as it stands, I think it would probably not just go through without any qualifications, without any limits, without any preconditions. And this is something I would be comfortable saying, just because of the fact that I think that every Senate, no matter how the composition might look like, will strive to to contain at least a little bit of this we're gonna have the last say approach. So that's the best shot I have.
Yes, I would agree, and of course it is the task of the German Constitutional Court to check the legislator, but the Constitutional Court itself states that the legislator is the first body who interprets the Constitution. And this shows again the task or the importance of the legislator. So from this point of view, I would say sometimes the Constitutional Court should be more restrictive in this kind of things. And of course, I cannot look to the future too, but I would say that the real situation of today's life, the fact that the world is globalized, people are connected with each other like we are doing right now. From this kind of things, the law cannot be different. So how to say, the law will follow the fact of our today's world, and our today's world cannot be seen anymore as single spots. No, we cross borders in different manners, and I can repeat myself, the law will follow, and therefore the German Constitutional Court declared that our principles, our values are universalistic. And I would say, to sum up, the fact how we are living, how we are going to live, will maybe destroy some old point of views, because, as I have said, a constitution will not be anymore accepted if if it is too far away from the reality of the people. And the reality is an international reality, I would say. So, last word, I think the daily life or how we live will be decisive for the future interpretation of constitutionalism or of a constitution.
Okay, thank you very much, Tony. I would like to give the floor to the last person. I'm so sorry, I cannot read in serial alphabet, but I see the hand, it's up. Who is it?
Yes, I'm sorry. My name is Julia Jauner, and I'm I'm a postgraduate student and a lecturer from St. Petersburg State University.
Great. Nice to meet
So
you.
I have a question for two researchers from Germany. So you told us about the fundamental values of the German basic law. So where can we find these fundamental values? So I mean, in Russia, for example, we can find them in the first and the second chapter of our constitutions. And what about Germany? So what do you mean by these fundamental values and their relation with the constitutional identity? Thank you.
So very briefly, I would say the basic idea of the German constitution is to protect the dignity of every human being. So I would say the basic idea of the German constitution is to be seen in an anthropocentric manner. It is geared to the protection of every human being. And from this point of view, I would say the other principles derives. So democracy, rule of law must be seen, must be interpreted in the light of this idea. But that's my point of view, not from a national perspective, no, because we share common values by our integration into the European Union or into the international systems, and therefore we have to define these values that are to be thought, that are pointed out to protect every human being in a supranational, international manner. In concrete terms, for instance, rule of law must be, or the principle of rule of law in Germany cannot be different from its understanding on the supranational level.
Raphael?
Yeah, well, I would just add two sentences. So if you actually want to look that up, so to speak, or if you actually want to have a reference, a first approach, so to speak, I mean, you've heard us talking quite a bit about Article 79, Para 3, so the so-called eternity clause of the Federal Constitution. And in that, actually, it is said that, I mean, you can do quite a lot of things in terms of amending the Constitution, but you cannot alter, no matter what, substantively, our Article 1, where we enshrine, the dignity of the individual, personal dignity of the individual, and Article 20, where the constitutional principles are actually enshrined. So, for example, that I just got up the English translation, that the Federal Republic is a democratic and social federal state, for example. So this is sometimes referred to as the constitution for the go, so to speak. So where the essentials, so to speak, are being condensed into actually a single article. So if you actually want to have a look at what this nucleus that we've been talking might entail, amongst other things possibly, Articles 1 and 20 are a good start, I would think.
Okay, thank you very much, Rafael. Thank you, Tony, Catriona as well for your interesting papers, actually. It was really lively. It's been really lively discussion as well, thanks to you. Before closing this session, I would like to make two remindings, actually. The first one is, as Professor Adrian Stone stated in our opening speech this morning, for the IACL, the association gives a lot of importance to make an official bond with the young and not so young scholars. If you're not a member of the association, please go to the website and fill the form and be part of our association officially. And the second one is, tomorrow we're continuing to discuss the concept of constitutional identity. The next session will start at 8 UTC time, which means at, if I'm not wrong, 11 o'clock at Moscow time. So the discussion, the title will be the Constructing Constitutional Identity. So I hope we'll all be together or continue to be together tomorrow at 11 Moscow time. Am I right, Sergey?
Yes, absolutely right.
Okay, then
Thank you
very much again for everything and to everybody, and I hope to see you everybody tomorrow. Have a good evening.
Yeah. Bye.
Bye, take care.
Bye.